Item 18, instructor called for. It has not been found.
My lord, what happened in this case, my lord?
18 supplementary.
My lord, supplementary hearing for juvenility, my lord. They, my lord, they prayed for the time of occurrence. It's
Yes. You are supposed to verify or something.
My lord, the instructions are not come, my lord. Can take a note next week in the weekly list, my lord.
Weekly, why? Let it be supplementary.
Supplementary for you.
18.
Next time, Thursday.
Thursday, because he has to seek instruction.
Yes. But my lord, weekly list item 145, my lord. Yesterday I have mentioned, my lord. I have already served the copy of deposition and
Vigilance. Vigilance.
Yesterday you mentioned.
Ready?
yesterday.
No, I'll contact my lord.
Are you ready
Wait,
with
please, my lords.
his matter?
Mellows will have stolen on Monday, Mellows,
Let it be Monday because he has to get ready.
because already two matters are fixed for today. Mellows.
Monday.
145.
I'll take it, but
Yes, ma'am.
be sure that I'll take it.
Lord, item 21
21.
of
Yes.
the supplementary.
Uh-huh.
Shall it be after recess?
Yes, no problem.
Hearing matters are already very
No problem. You be relaxed.
Mellows, last item of your lordship's board. Item 22.
Yes.
Mr. Das will be appearing in this matter.
Yes.
So he is not well 1 week after, Mellows.
But who is?
We have informed the appellant counsel.
Have you?
Yes,
informed?
he has informed.
Huh? Sorry.
Item 22.
Mr. Das.
Yes, Srimanta Das.
Oh, he's become serious what?
No. Srimanta Das.
Yes, he was not well.
He is not
Fell
well.
down.
He met with an accident.
Oh.
So that is the reason he has also
He's
informed
all
the
right.
appellant counsel.
He's all right. No problem.
He is all right. On Friday, he has a checkup.
Oh.
On Friday, things will be
Okay.
clear.
Isn't it?
1 week after.
Personal difficulty. No. Sanjay. Just Mr. Sanjay Das is also admitted. That's what he is saying.
Mr. Sanjay Das is having some stomach upset, perhaps.
But he is also not there.
He is also not there.
My lord, for admission, I will attend 1-3 item 3. I was admitted in Blue Hospital yesterday.
He has become fit now.
Are you?
He told me fit.
Eh?
Again, I am going to Blue Line Hospital, my lord, after attending your lordship.
No, you must go there. You forget about these cases. It will remain in the board. Don't worry. You go and.
No, high fever, dehydration, my lord, only.
No, you must go. I'll keep it for tomorrow. No problem. You go.
No, item 3, your lordship may admit bail granted a fine state.
Okay, then.
Formal
Don't worry,
order.
I'll do it. And presence marks the presence. Item 3.
Formal order.
Press matter here.
Formal order.
Yes, no problem.
Obliged, my lord. Free copy be granted, my lord.
Sentence is 3 years, my lord.
3 years. Okay. So bail granted. Realize will find days and admit. Yes.
My name may kindly be reflected in the cause list as well as in the record, my lord.
Yes. Cause this. 3 items. Yes.
Obliged, my lord.
Okay. Yes. BC mentioning.
Item 1.
Item 1.
Item
I-
1.
one and
that
two.
To be mentioned
Mentioned.
matters.
One
Old
and
matters.
two.
1 and 2.
There is. I
Fine.
told you.
That was the issue, my lord.
Yes.
But in
I told
item
you there
1,
are 2 issues.
my lords, but in item 1, I was going through, my lords, there is no fine amount has been imposed by the court people.
But it has to be.
Yes.
That's the law.
Yes.
And one more, there are 2 things which I have flagged.
Facts.
One is if you have TRC,
TRC.
then in absentia, no TRC.
No. He has to be present. Apparent has to
In
be present.
absentia, there can't be
No,
TRC. This
no.
is one thing. Second is, and fine is there. It's not or fine. So
Yes.
fine has to be imposed.
Yes.
Once fine is imposed, then default sentence has to be imposed.
Yes.
A default sentence can't exceed the
Fine amount.
substantive sentence.
Yes.
If TRC is there for default, what will be the sentence?
Yes.
Half TRC. It's very difficult for you.
Yes.
So legally, you have a big problem insofar as this. I dictated the order thereafter realized technically this is not sustainable.
Yes.
I am passing it
Pass.
over. He may
Yes.
assist.
Any moment when he comes,
Yes,
he can
yes.
take up. 1 and 2 both.
1 and 2 pass.
Item 4.
May please your lordship, my lord. My lord, in this case, it is a case under section under PC Act, read with 420 and 120B of IPC. The trial is yet to come. Now waiting for comments. Trial is to commence. But, I have not-
You are against what? You are against.
207.
Against the order passed by the Lord and Session Judge under section 207 of CRPC. As per section 207 of CRPC,
Hmm.
my lord, the accused has to be provided with all the police papers freely. But in this case, the Lord and Court below has directed that we will not supply you police papers because these are voluminous. A part of a document, 200 or 250 pages.
Let it be voluminous, whatever. You have to supply.
May I submit one thing, my lords? Your lordship, turn to page 19, my lord. My lord's friend, my lords, is in fact, he hails from a judicial prestigious cadres, my lords. In fact, he understands the ground realities.
What is it? No.
Lordship, contact page
I'm not
19.
interested in ground.
No,
reality.
no,
I'm
he
interested
understands.
in the right of the accused.
What, my lord,
They
page
don't
19.
rely upon the document.
My lord, page 19, my lords, page 19. My lords, you can see the last but one line.
Yes.
The prosecution is directed to supply. These are fast case coming. I'll take instruction, but lords, you can see that the prosecution is directed to supply the above documents to the accused. The defense counsel requests to inspect the voluminous document in the court hours. What are the documents can be provided? He is required to provide it.
The accused is not on the mercy of the prosecution. You are relying upon the document. You have to give it. That's all.
My lord, yes.
Let it be voluminous.
It is my fundamental right, my lord, indefeasible right.
That's true. That's true.
I should be provided
It's
with
not
police
the
papers.
accused is not on the mercy. You come and raid somewhere and pick up almost everything in the house, including the garments,
My lord.
and you throw them. This is what is
lord,
raiding is
my lord.
taking place.
No,
And
my lord,
now when the documents are there, then you say that it is voluminous, I will not supply. I will satisfy.
My lord, yes.
May pray, my lords, let it come Monday, my lords. I will just if anything is there, my lords, can be given. Even about that.
Where is the question of
Trans-
if and but, sir? You have to give everything. Otherwise,
That
you
is
make
the
a
law, my
statement-
lord. But there
you
are
make a
some.
statement that the documents which are we are supplying, we will rely. The document which you are not supplying, we will not rely. Make a statement, I will record that.
My lord.
These documents are to be supplied. That is, they has accrued the rights, my lords.
Can't be a
But
ground that
certain
voluminous.
document, huge voluminous.
what-
My lord, no voluminous.
Vegetation
But
right
there are
is
many
there.
things.
But
Now
a
you can
dictionary
scan.
is a-
Now you have a lot of
अच्छा इटा दे दो पेन ड्राइव पे नहीं दे पर
whatever you
It
do.
can be. As per-
Better-
my lord, if the documents are voluminous, it is only 200 to 250 pages. What is the lexicon meaning of volume?
200.
Volumes are
Is it 200 pages?
only 200 to 250 pages. We are also ready to,
digitally.
Lord
Yeah,
Directs, we are ready to
no.
make payment for that also. But why will not be supplied? We will be going to an inspection.
Pen drive then.
Pen drive, whatever.
Pardon.
He is entitled to know. How will he
Yes,
defend
madam.
without the
Well,
document?
250 we have there is sufficient Xerox machines are there in the
Hmm.
court and it
But
can be supplied. madam.
That is their outlook.
It will be convenient where in the digital world, my lords. Let him take all the copies using his pen drives. my lords.
In the present petitioner has assailed the order dated 25/1/2024, passed by the additional sessions judge Vigilance Bhubaneswar in TR case number 7 of 2011, whereby his application under section 207 CRPC has been rejected. The court below has rejected the application and they declined to
part.
supply the
In part.
police papers in part.
Part,
on
they
the
have
ground.
completely rejected our prayer.
Part on the ground that the police
Certain-
paper are
certain
voluminous and they can't be supplied. I am completely in disagreement with the order of the court below. The petitioner, being an accused, has the indefensible right to defend himself, and all the police, all the documents and materials relied upon by the prosecution needs to be supplied to the accused without any doubt or variation. In that view of the matter, the impugn order is set aside and the prosecution is directed to supply all the materials, documents relied upon for the purpose of which form part of the charge sheet.
My lord.
Form part of the charge sheet
Yes, my lord.
within.
But Lordship, may indicate one observation. It is open for them to use the pen drive in digital in case of.
See,
Why-
modalities. See,
Why should we
modalities.
take a strain?
Trial court can work out the modality. Why should I say the modality is also?
My lord, this honorable,
Charge sheet within a period of 2 weeks. 2 weeks hence.
Yes,
2 weeks hence. with this observation, the petition is disposed of. Yes.
No, I rely on my learned friend lots. It is 200, can be, he can be provided.
200 or nowadays
I
you
got
can
the-
get a pen drive, scan
Yeah.
it, give it. There are many ways
Ways.
to do it. Yes.
Granted 2 weeks more to
2
supply.
Urgent copy.
Item 5, kindly grant passover.
Yes, passport.
Item 7.
6. Yeah, that, I thought. Yes.
No, 6, 7, these are the more, no? 6 টা সেটা সে weekly list র কইতে পারে।
Weekly listing.
বোস বাবু যেটা কইলে তো?
That is weekly.
না, না,
No.
That
That
is
is
other
weekly.
listing.
That's what is the first case?
মানে against an order rejecting my discharge application.
Hmm.
Both the cases, both the revisions arise out of 2 petitions.
Two
Rejecting
different cases. In both the cases, your discharge application is rejected.
has been
So
rejected.
you have prepared 2 petitions.
Yes, madam.
Okay.
Here the ground is, allegation is, your lordship may kindly come to.
Petition is pending since.
No, this is coming the first
Sir,
time.
this is a fresh matter.
Lordship may issue notice, my lord, I will take it.
No, let us see if notice is required
Yes.
or it can be disposed of right now. Yes.
Madam, allegation against me is just page 14,
14. 1-4.
internal page 3, running page 14.
Yes.
3 lines from the top, it is also revealed during investigation that Vaikunthanath Maharana, this petitioner, who was then assistant teacher of so-and-so school, put the signature of Krishna Chandra Barik on a revenue stamp on so-and-so 14/7/2005 illegally and received cash of 1,10,000 rupees. I took a ground in the discharge petition that this Krishna Chandra Barik is dead. He cannot be examined anymore. And the handwriting, the standardization of my handwriting, my signature with that of Krishna Barik, the examiner says that no definite opinion can be given. So I prayed that I should be discharged. Because there is virtually no evidence and I am a man of 70, 75 years suffering.
Yes. What do you say?
Just, I'll just apply my mind.
See,
and come
this
back.
Vaikunta has gone. And
I-
signature doesn't
I
meet.
got it.
Then what are the evidence? Nothing. You will put him to do a trial.
Lord-
It's a futile exercise.
Yeah, let's fix a date, no, I'll just talk with the IO and come back.
I'll issue notice and returnable 1 week after. 1 week after. Okay. 1 week after. Only issue. Yes, 7.
My lord, your lordship, the interim order I have prayed for. Your lordship.
I will dispose it up. Don't worry. No interim. I dispose it up
No,
within 1 week. Nothing is
I
going.
also agree that he has got an arguable point there. No, I will come back to lordship.
So
Can we
don't
dis-
ask for adjournment. Next Friday, I'm putting it and finish. I'll
Oh,
finish
yes.
it up. Next Friday,
My lord, he has posted the case to 2nd August, or he said that I will issue NBW.
No, I'm saying the came.
Fair.
You manage it.
Yeah, I
It is pending in
I
High
will
Court.
file an application for adjournment, your lordship may observe.
That you manage it, no
see,
problem.
if that observation is made, this 2024 petition will be taken up in 2034.
No. Your
That's the
lordship,
problem. Thereafter, nobody will come.
no, otherwise.
That's the reason I'm not passing these. See, I have seen 2011, this kind of orders are being passed. 2024, we are here. The matters are still pending.
Mr. Mukh, why do you say the public procedure doesn't require this?
Either you want a discharge, let it be discharged. Finish it up here.
2nd August.
And after 24 or 25 years, we will keep on searching whether he is alive or not. Let it be.
Alright,
You tell me.
2nd August, your lordship may post it to 2nd August.
2nd
Friday.
August.
Friday. I will show
Yes,
the
2nd
list.
August.
then.
No further adjournment will be given
Yes.
in both the matters.
Yes, ma'am.
On that day, I'll finish. I'll pass the order this way or that way. Both the matters. Both the matters. 6 and 7.
Item 8.
Mr. That, please don't ask adjournment on that.
No, I
Then on
promise.
second day, he has.
No.
This will be infraction.
I got the points, my lord. He has got an arguable points, my lord. I
Then-
understand it, but
Second,
only.
second one, I have not seen it. But the first
Same,
one, you
same.
have point.
Same, because this is in respect of GPF, the other one is in respect of house building allowance.
Okay. That's the same person.
Same person, same act.
Whose name you have
Yes.
impersonated.
Second one is a better case because there is a check. It is alleged that I have received the check by signing his name. So I cannot misappropriate because the check must be in the name of the deceased.
Okay.
To be mentioned, my lord.
Yes, yes. Sir, the to be mentioned, there are two problems I have flagged. First problem is in absentia, there can't be TRC. This is one problem. That's not a bigger problem that we can find out. The second problem is in the old act, it is the sentence and fine. Okay. If I'll pass an order of TRC insofar as sentence is concerned, looking into his age of 80 or 90 or whatever, fine has to be imposed.
Some fine has to be.
If I impose fine, there must be a default sentence.
Yes.
The default sentence can't exceed the
Original sentence.
Substantive sentence. What will I do?
Yes.
Sir will also be
Yes,
assisting.
yes.
I am on that point in item number 10. That is why I rose up. The same thing I mean.
So there is a huge technical. So
No,
you
my lord,
like
my
people
lord,
can
may
ask-
say, my lord,
The
may.
question is where I am in. There is an application is filed by the legal heirs for setting aside the abatement and to continue the appeal.
Right.
Now the question is 394 says that the appeal abates when there is sentence. And the appeal does not abate when there is fine. So what happens when there is a composite order? Sentence plus fine. And the answer is given, I have brought 3 decisions. One of the Supreme Court, one of Calcutta High Court, and another of Allahabad High Court, where they say that if it is a composite sentence,
Appeal abates.
appeal does not abate.
Oh,
Appeal continues.
good.
Yes. For my lord, we impose fine, they say 10,000. And
The
in
appeal is
default,
very high.
so sentence is 3 years or 3 months, whatever, 1 year, whatever
Right.
it may be. Minimum is 1 year.
Huh.
So my lord can do that if you will
No,
not.
but
impose-
there is the default sentence can't exceed the substantive sentence.
Yes.
So
So,
if I
for example,
substantive sentence, I am
in a,
making TRC,
for
how,
ex-
default sentence, how can I make more than
for
that?
example, my lord, in first case, Kailash Chandra Buduli,
Right.
there is no fine. No fine is there.
That's wrong.
That is,
Because and fine.
and
How can the
my lord may impose some fine, 5,000, 10,000.
no fine, the amount is not more important. Let it be 1,000 whatever. In default, what will be the sentence?
Sentence, my lord, that is not, that has not been.
I tried to find out an answer, I didn't get that, so therefore I got it listed. I have dictated the order also. And the last I got stuck. And I called Mr. Rijvi to give some insight about it, and he said that I
Yes.
research on the subject. And I
Again,
said
my
that
lord,
the senior can only.
yes, my lord, but I have not thought of in that line. My lord, fix
Yes.
up this case to some of the dates, say 9th of August.
9th, both the
I
matters.
will answer definitely.
Please, because this is very
My lord, yes, yes, yes,
very
this will be
interesting
answered for
issue.
all times.
interesting issue, and many matters can be disposed of if proper assistance is
In
given.
both the cases, I think,
Please,
yes, yes, I will enlighten.
please look into it.
My lord.
Yes, 9th. Both 1 and 2. Yes. And sir is going to argue that that also we will take care of that position.
My lord,
Item 10.
I will also hear.
Yes,
I will be here.
yes.
Item number 5 may be taken up some other day, my lord, 1 week after. Item number 5 was also passed away.
5 agent code, 5. Yes, problem. Yes. Yes. Bail, the urgent code. Bail matter, if they don't come, let it be.
Bail matter, my lord, earlier your lordship has dismissed due to the not following to the,
Anyway, he is not there, then urgent it for next week.
yes.
What is this republic? Yes.
In compliance of order, 2 things I have done, my lord. One, my client has appeared before the IO as per the
You are supposed to file the reply.
reply has been filed.
You, Mr. Naik, have you got it?
Yes, your lordship, I've got it.
Got the reply?
Yes.
You want to
Yes.
respond to that?
I want to respond, but before that, I would like to make some points, then I'll respond, your lordships.
You respond it.
Just indicate something, then I'll respond. I'll take time, your lordships.
In the meantime, I'm required, I will go again and appear before that.
Let us see.
Lordship, may kindly come to section 114E of the Indian Evidence Act for a moment.
You tell me, Nina, what is the point?
the court may presume existence of the certain facts that judicial and official acts have been regularly performed.
No.
Now, Your Lordships, in 2017, he has given a complaint before the magistrate about the IO and the conduct of the IO. The magistrate sought a reply from the CBI SP, Mr. Manish Sinha, at that point of time. And this inspector was given a clean sheet by the magistrate that this man is giving false complaints. Now, if Your Lordships will kindly come to the reply, in reply, he has stated something. He has annexed the copy of the modification order dated 6/4/2023. And if Your Lordships will kindly come to the first paragraph of the reply, page 3, Your Lordships, he is stating that all the facts and circumstances leading to this application which prays for the cancellation of bail were raised in the counter reply to the said modification application. Where is that counter reply, Your Lordships? He has not annexed it. I checked out, Your Lordship, there was no counter reply filed. So this is a false statement again made before this honorable court to get a relief, Your Lordships. And Your Lordships may kindly note down a judgment, recent judgment of the Honorable Supreme Court by Honorable Justice Mr. U.U. Lalit and Honorable Justice Mr. Narasimha, order dated July 11, 2022, Your Lordships.
Yes.
Peri Kasangra. It's a so moto contempt, Your Lordships.
Citation.
I'll file it, Your Lordship. Civil contempt number 3 of 2021. It says that a person who makes false statement before the honorable court makes an attempt to deceive the court. A person who makes false statement before the court makes an attempt to deceive the court, interferes with the administration of the justice, and is guilty of contempt of court. The court not only has the inherent power, but it would be...
What you intending to say that he has aggravated now?
Yes, Your Lordship. Where is the counter filed? He is stating false, giving false statements that I have filed a counter. Let him file the copy of the counter, Your Lordships. Lordship may record the statement of sir that a counter was filed. And I have raised those objections in the counter and let him file a copy of the counter which was earlier filed in the IA. Lordship may record his statement.
Have you ever filed?
No, my lord, I'm just clarifying it, whatever my lord will say. When this order was passed, he was very much there. His submission has been recorded. There is a part.
Where is the submission recorded? Lordship may kindly come to page 34 is the order.
Was there any counter?
He is not allowing it.
Even.
No, my lord, I have no idea.
No, why has written a counter has been filed?
Appeared and has
No.
countered
Lordship
my
may kindly read
objection
that
by
statement.
place.
Lordship may kindly read that statement. A counter was filed.
1 minute. 1 minute, Mr. Naik. Let him.
Mr. Naik, I have done.
You have raised a point, very valid point. Let him answer.
Yes.
I will inquire whether counter is filed and maybe the mistake it has been done is a typographical mistake. Maybe, may not be, because I'm not authorized to give an instruction this. And I'll inquire with the earlier counsel because earlier counsel Lalit was.
You have made a very specific.
Here, Your Lordships, he's online.
My lord, intent what to be made that when this order was passed, objection was made, he was very much there, his submission is recorded. Maybe the counter, maybe some
No, Your Lordship, Mr. Lalit is here, Your Lordship. Lordship may kindly ask him.
That is hardly
there
matter,
online.
Mr. Naik. You are come on the
No,
point.
it doesn't matter. You have
case.
given a false statement. How does it matter? Why you are giving false statements?
I'll explain how it matters.
All the
I'll
facts,
explain, let me allow
circumstances
me.
leading to the applications.
There is no point counter arguing.
Yes,
You file responsibility.
Yes.
But why are you creating problem for yourself?
No, I'm not.
By making, you are making
It
an
may,
affidavit.
well, it may be bona fide mistake to say counter has filed
No,
and
not
not
bona
filed.
fide. It's a false statement.
Very
Filing of a
specific.
false affidavit itself is an offence under 197.
You are inviting unnecessary problem for yourself. Why
Well,
are you doing that?
I'm not inviting. I'm very much clear. I'm appearing. Whatever the condition imposed, I'm ready to do the last date of hearing. I have said that whatever the condition,
no.
it is the CBI who wants that.
Your Lordship is not doing any charity.
General approach is, if bail is granted, the court shouldn't interfere. If you are doing some mischief, then some additional condition, whatever. But the fact that you are threatening the IO, you are doing all these things, and thereafter you file the counter again, wrong statement. All these things are aggravating.
Your Lordship, one line only. Your Lordship, only one
That's the
line.
problem.
Your Lordship, only one line.
Otherwise,
Your Lordship,
the
only
bail cancellation will take 2 minutes to dispose of.
Your Lordship, only one line.
You only create problem for yourself.
Your Lordship, only one line from the CD.
I'll
Lordship,
check
only
it,
one
madam,
line.
because he has a counter.
Put it next week, sir.
Your Lordship, only one line from the CD. I know how to manage the High Court. I know how to manage
I
the
will
High Court.
clarify. I have given everything, my lord. I have
If
surrendered
you
before
report
you. I have
anything against me, I will make false complaint against you, as I did before the special CJM CBI previously. And this statement may be recorded, your lordship, that a counter was filed and these issues were raised because
But he's
Mr.
not
Lalit is
allowing
there,
me
he
to
can clarify, your
the
lordships.
position is coming on point.
Anyway.
I have filed SLP. I have filed SLP after giving representation to the CBI. I have placed on record the representation I have made. The problem started when I filed the representation. Why I filed representation? Because every time he is giving 3 days time to appear. I have annexed, my lord, the summons issued by the IO. He is coming on the 11th. He is saying that you come on 14th. I am not there. That is the only root cause what the differences got created. Otherwise, nothing. He has admitted last date of hearing that 70 times I have appeared. I am saying more than 100 times I have appeared. He has filed the same charge sheet, same role, same allegations.
Your lordship, one small
Nothing
point.
new, my lord. 10 years has been passed. 10 years has been passed. He has
Your
filed
lordship, he is saying
sheet.
that he has appeared.
I am kindly examined. I have filed a charge sheet.
Next week, we'll see. You file
Your lordships, he has. Your lordship, one more thing, your lordships. He may file an affidavit.
At 2 o'clock, we will fix it, finish it up.
Well, I will file my affidavit for that to clarify the things.
Now you understood where you.
No, I understood. It may be the mistake of juniors and juniors while talking about that. It happens. My lord is very much aware about
Your
it.
client is very smart.
No, my lord.
He will not.
Senior
No,
man, your lordship.
my client is smart. My client is, my lord, is suffering. His wife, my lord, kindly
He
appreciate.
accused says that I'll manage High Court. Accused
My lord,
says that I'll manage the IO. He gives.
I'm not going on that because he has created that narration and perception, my lord. My client's wife is suffering. She suffered the cancer and she's hospitalized there. Wife is and mother is, he's the problem, my lord. And at that time, 2021, that was the time when he started summoning like this. If my client is in AIMS, his wife is suffering from death there, and he was being called for 3 days, 4 days, come. It was explained to that my mother is in problem.
Maybe you're correct.
That was the only reason, my lord. And I'm the person who appeared 100 times. It is not that 1, 2, 3, 4 times. And there is no supervening and overwhelming circumstances at all. And if you allow me, I will examine only 2 pages. My lord, everything will be settled. What a complaint, the basis of this case is complaint. Kindly
Your lordship, the respondent has been.
I don't want to go. Merit, I don't want to. You have got.
Your lordship, one more thing. Your lordship, one more thing. One more thing, your lordship. Paragraph 4, he has written that the respondent has been appearing before the petitioner 125 appearances. Now, lordship, when the CBI inspector will call, either a notice will be given under 160 or 41A or 91. Let him file the copy of the notices, 125 notices, your lordship.
I don't know what he's talking, my lord. 10 years.
There was a direction that he should appear every Sunday or Monday.
No. He said that. No. If there was a direction.
So it means
there may not be notices.
No, 125 is also a false statement. No, your lordship, 125 statement.
Approximately.
Please wait. Please allow me to argue. Please wait. Your lordships, there is a difference between appearing. Because this is my petition. Why should I allow you? Your lordships, this is my petition. Let me argue. Your lordships, by going every Monday, he is complying the High Court's order. He is not doing any charity. As far as summoning by the IO is concerned, your lordship, that should not be confused with the court order. Please ask him to file the copy of the notices. How many times the IO has summoned him? Please file it.
I have filed 2 occasions. Otherwise,
you have not filed. You have filed only 3 notices.
Mr. Naik tried to.
You have filed only 3 notices. Kindly file those.
We'll see.
I will appear again if my lord say like this.
1 week after.
2 weeks.
And one more submission.
And keep on appearing in the court, the IO and
yes,
the supplementary charge sheet has to be filed. That's all. Yes.
That's a 2 weeks time.
Item 10.
Just give a date by adjusting.
Lordship may
kindly give a date, otherwise he's. Your lordship, otherwise the date will not come.
Date will be given. Of course, date will be given.
It's after 2 weeks.
And Mr. Naik, not 1 week after. Next week, leave next week thereafter. 7th.
7th of
August.
What's it after 10th August, 11th or 12th, 7th?
Okay. 13th? 13th bill
13th August.
13th.
Yes, your lordships.
Mr. Naik, counsel for the petitioner, seeks 1 week time to respond to the reply filed by the respondent.
Your lordship, 7th will do. Your lordship, 7th will do. 7th, your lordships.
7th, no problem.
7th will do.
Okay. 7th. File the reply then. Okay.
I'm in DC. 7th before CBI.
May I please your lordship? In the cancellation of bail application, why should I monitor when you go, when you don't go? there is a direction, you go and
If I'll ask, then I'll go, my lord.
May I please your
Without that,
lordship,
I'll
I
go
am in
without-
similar time
without,
audible.
we'll
What
see. If he doesn't ask, then next time he can't complain that. you
May I
can't
please your
ask.
lordship?
Great.
Obviously.
Great.
Yes.
May I please your
Yes, sir.
lordship?
It's 7. Already Mr. Singh is appearing and argued. Yes. 10.
Grateful.
Item 10, Lordship may kindly see section 394 of this CRPC.
May I please your lordship? My lord,
Mr.
may I
Mishra
please your
is
lordship, I am
asking
on
for-
item 9, my lord.
Array, it is already over.
Yes, that
I'm
will
in
be my
item 10 now.
lord, there is my lord, comes that my power is there with Mr. Singh is with me. That last order, my lord,
The manner in
that,
which you people are conducting I think there is something more than what the pleadings are reflecting. Why in a cancellation of bail, how many hours you are going to argue? One counsel argued, it's all right. If you want cancellation, tell me, I'll cancel it right now.
My lord, perhaps he wanted to clarify that earlier he
What
was.
clarification? You are appearing.
I apologize, my lord.
You
I
can't
apologize.
take the proceeding like this.
I apologize.
Somebody is appearing in the court, somebody is there somewhere else in a cancellation of bail, and you have wasted 10-15 minutes.
Earlier
By that
they
time,
have,
I
yes.
could have
I
finished an
apologize.
appeal. What is this?
Extremely, extremely well.
Don't cross a limit. Yes. Yes.
Lordship, section 394 CRPC.
394.
Abatement of appeals.
Yes.
Subsection 1. Every appeal under section 377 or section 378 shall finally
One minute,
abate.
sir. 1 minute. 390?
394.
394.
Yes.
Abatement of appeals.
Okay. Yes.
Subsection 1. Every appeal under section 377 or section 378 shall finally abate on the death of the accused. 377 is government appeal. 378 is appeal against acquittal.
Yes.
This is appeal against conviction. Conviction is subsection 2. Every other appeal under this chapter, except an appeal from a sentence of fine, shall finally abate on the death of the appellant. So the position is clear.
Except an appeal from the sentence of fine.
Fine. So if it is a sentence only, it abates. If it is fine only, it does not abate. What happens when there is both sentence and fine?
Component.
The answer is given by the Honorable Apex Court as well as the Allahabad High Court that it does not abate. If fine is there, the appeal will not abate.
Even if sentence is there.
Even if sentence is there, the appeal needs to be heard. And accordingly, my application needs to be allowed by incorporating the legal heirs. And there is no limitation.
But in your case, there is a sentence as well as
Sentence as well as fine.
Yes.
So the legal heirs should be there because the legal heirs also have got a say as regards the fine.
Yeah.
That's last time you were on the point of limitation.
Limitation
dispute
प्रश्न
the
ही आव नहीं
settled position matters.
abate तो होबो नहीं आव limitation कोट हो
But there is
Abate only continue. That's what he says.
provided the mechanism has been malord is followed.
This
What
is
is
a
the
formal application. Section 5 application is also not required.
It's not required.
Then-
Only the legal heirs.
Then why there is
that is
mechanism
need to
given
come.
balance of 30 days? The intention
30
of the
days
legislature.
for abatement. When there is an
One-
order of
the-
abatement.
It is only for the abatement. Once it is abate, he can revive recall the abatement anytime. Once the knowledge comes. That is his proposition. And it seems to be correct.
First, may I just place the provision matters where the limitation has been given.
Limitation for the purpose of abatement.
Yes.
Within 30 days. Suppose a appellant dies,
Yeah.
a sole appellant dies. The appeal survives for 30 days. After 30 days, it abates.
It abates.
Within that 30 days, if somebody wants to argue, he can argue. It doesn't abate at all. After 30 days only it abates.
It only abates.
Suppose somebody dies, some appellant dies today. Within these 30 days, you can come and argue that appeal as it is, as if it is an appeal by the appellant. It doesn't say that the appeal will abate the day it is come to the knowledge of the court or the next day. Only after 30 days it abates. And after that, the abatement can be recalled once some application is moved. And therefore, section 5 also doesn't apply. That is what his case is. Do you want to respond to that? This is the position he has now made it clear.
Let it come
2 o'clock, you come.
today itself.
Tomorrow you come.
Next,
This point is very clear. So if you, tomorrow you want,
next week, next Thursday, minutes. On this point one.
what is
No problem. No problem.
because it's clear, very clear
Yes.
now.
Copy the.
Yes.
But you have not enlightened, sir, that part, the one
Fine part.
sir was arguing.
No, I'm
How to-
not on that. I thought that this is this point.
But this is a different issue, but
This is-
the
That
issue
I,
which was arguing,
that I will. That I will.
just see if we can assist. Yes. Next. Yes.
May I please your lordship? The IRDP scheme,
This is for final discussion.
Yes, ma'am.
final hearing.
Are you ready, Mr. Rijvi?
Yes, ma'am.
We can go ahead.
Yes, ma'am. It was
Then-
fixed for today only.
Can I just run through the list thereafter? Just
As you-
I'll run through small matter, then I'll
As-
start.
as-
Because it will take at least
Not likely to take much time, very
Half an hour
small,
minimum.
short. Anyway, I am.
half an hour you are in your standard. I'll just run through the list,
Yes,
then hearing.
Yes.
Okay. Yes. Well.
Your lordship, may kindly have a glance to the noting in the cause list, my lord.
The service it's complete.
Not yet received.
Mr. S.K. Pradhan was appearing. He said that I will not appear. Notice was issued. Service complete. Pass over करो देखते हैं. अगर if somebody comes, it's all right. Otherwise, we'll appoint a amicus curiae.
Yes, ma'am.
Yes.
The name of the amicus curiae may not be reflected.
No, I have not appointed so far. I'll appoint.
In case my suggestion,
Wherever there is an amicus curiae appointed, his name should be reflected.
no, may not be reflected.
Huh?
Because the once the amicus name is reflected, I feel lots more, the real lawyers comes.
But the amicus curiae will miss the list. That's the problem.
That will independent to them personally.
See, in that case, what happens is if the real lawyer comes, he has to assist the amicus curiae.
In that way, also both advocates are appearing.
Appearing. Otherwise, nobody
So
will.
that's the problem. You don't come, amicus curiae appointed, next day you appear.
Yes.
Name of
And
amicus
the poor amicus curiae reads and prepares
And madam, rather it goes the other way. If the amicus is appointed, immediately the lawyer concerned appears also.
That's right.
Yes.
So the amicus should get precedent of a hearing, then the 13. Yes.
So this is
Yes, sir.
At the outset,
Hmm.
annexure, the lead copy of the annexure 1, they have not supplied.
Next one.
Annexure 1,
You can't read it.
they have not given to us.
item 13.
Yes, sir.
You want the annexure 1?
Annexure
Very difficult, sir.
have not given.
I'll give it to in course that now only.
You just have to get it typed.
No,
The handwriting is not readable.
Yes, yes.
Ask the department to sir, type it and give it.
Yes, yes. That, type it.
Type it. Give it.
you will dispose of. I'll see that. ठीक है, ठीक है. I'll keep.
When?
10 days perhaps. 10 days.
6.
Item 40.
Sorry?
My lord, 14, the lordship has directed to take instruction regarding present status and well-being of the petition.
Yes.
Actually, what happened, my lord, is wrong. There is a typographical mistake in your lordship's order. And we can to see that order dated 15/7/24. That was communicated to our office and notice, and the inspection was called for on 22. But my lord, your lordship, my lord got that order, my.
Yes, I got that.
My lord, in the para 2, my lord.
SP Vigilance, Parampur.
My lord.
He directed. It should be?
Only IAC, I will take instruction from the IAC.
Oh, this is not a vigilance case?
This is not a vigilance case.
Oh.
For the wrong order, my lord.
Copy paste. Copy paste vigilance. Yes. Right on. The IIC?
That is a.
No, England Council for the respondent submits that in the order dated 15/7/2024, an error has occurred. Instead of a direction to IIC.
No, that is a Barampur Town PS.
IIC Barampur Town PS to submit a report regarding the well-being and whereabouts of the petitioner. SP Vigilance Rule Barampur. Barampur has been mentioned in the order. Accordingly, he needs the correction. Correction. Next paragraph. The IIC. What IIC? Barampur.
Barampur Town.
Right. Barampur Town. Barampur Town PS is directed to directed to verify the well-being and whereabouts of the petitioner and release a report within 10 days. Yes. Please the matter. Yes.
My lord, next 15 also, my lord, same order was passed.
Same problem?
My lord.
15. Why don't you see, you people see that the why didn't you point out on immediately, waiting for the day to come?
Well, when the
there was
order
a
was,
mistake, you should have told.
well, when the order was communicated to our office, then after I knew.
When it was communicated?
It was communicated on 22nd May.
22nd, you should have intimated. You could have saved the time. This is SP Vigilance Anugol. Instead of that, what it should be?
And that will be PS Bontola.
Bontola.
Right.
It is PS Bontola. It is like SP Vigilance Anugol. Where from you people are getting all these things? Where from you got that SP Vigilance Anugol? Why have you written this? Huh? Where from you got, let us see. Where from you got HP this thing? कुछ भी लिख दोगे क्या? Where from you got this in the entire file? There is Barampur and here is Vijanpur. SP.
What happened in this case, madam? Actually, madam. Before this case, madam, there is a vigilance case, madam.
I know the same thing. He pasted and gave I sign it. I can't keep on searching in both the cases you've done.
That is.
You please vote the file along with this. I have to take the. I'm not leaving it. There is end to it. You will be suspended. No, you will be suspended. मजाक लगा रहा हूँ. Yes, next.
Item 16. Well, this matter will be taken up next week.
I have given 10 days time to Arjun.
Item
Yes.
16.
16 matter adjourned.
What is this matter? Adjourn is not by way of right. You come without file, without anything.
Senior is out of session.
As if
457.
as if you have a birthright, you come adjourn. What is this?
ठीक है जोर कौन
Senior is out of station. So
Huh?
senior is out of station. So
What is this matter? You Go and get the file and come. No, nothing. Pass over. Go get the file, read it and tell me what is this case. Without file, without anything.
Ball played again.
Eh?
It's a good ball.
But he has to read, and this is the time where, let him read and tell what is the case.
Item 17.
Item 7.
Yes.
Let's see the petitioner has challenged the judgment and order of conviction and sentence passed by
Pardon
the
to-
London
Pardon to mention, your lordship, I am in BC, my lord.
16?
17.
My lord, I am in BC, my lord.
Yes.
My lord, item number 16. Kindly pray for an.
See, your junior has come without file, without anything.
My lord.
Why have you not given the file at least?
My lord, due to some urgent work, I am not.
No, I am making him to read from the court file, and thereafter only I will adjourn. Okay. You read
Lordship,
it.
kindly be urgent to some next other.
Let him say that. I am not entertaining your request because he is there in the court. I will entertain his request. Subject to condition, he reads and tell me the facts. Read it and tell me the facts. Yes.
With
17.
17.
Let's see, the petitioner has challenged the judgment and order of the conviction and sentence passed by the London STJM Rairanpur in GR case number 123 of 2005, trial number 509 of 2005 on 11/4/2011, wherein he has been convicted the appellant under section 354 and 448 of IPC and sentenced to undergo SI for 6 months for the offense committed under section
Are you ready to
354.
argue the matter?
Let's-
Ready?
Yes.
2 o'clock, ready. 2 o'clock, matter of 9? Let him come. Get ready and come. We'll finish it up today. Okay. If you are ready.
Let's-
Huh? It's all right. Thereafter. Last time also you argued very well. But the only thing is you have to structure the argument. Don't read one line and go to some other line. You tell me the proposition, thereafter you take me to the evidence. Like that, structure your argument and get ready. 2 o'clock will see. Okay? Yes.
Item 19.
Supplementary paper.
My lord, in this case, the case was a non-appearance adjourned, but file memo, case was listed for.
Yes. Yes, sir.
19, my lord. The petitioner challenged the order of a conviction and sentence passed by the learned assistant session judge Athagad, thereby convicted the petitioner to undergo RI 2 years for the offence 436 and 34 IPG, and fine 500 is imposed on each of them in default or payment. They are to undergo RI of 1 month. Both court has convicted. Trial court also convicted. Punishment maximum 2 years. In the meantime, informant is your neighbors due to appear and file settlement. The matter is settled. Punishment 2 years. Petition number 1 and 3 are the government servant retired but without pensions because one conviction case pending against us. Now the matter settled. Maximum witness are the hostiles. PW1 is hostile. PW2 is a hostile. Only PW3. PW3 is eyewitness kehi na. Ye anuman kariki कहउचंती. All are anuman kari कहउचंती. But matter is settled. ଆଉ ମାନେ ବୁଢା ହେଇଗଲେ फिर pension ପାଉନାହାନ୍ତି. So matter is now settled. ପାଖ ଘର ଲୋକ.
After 2 court convicted, you can't settle and get out of it. You have to show me the evidence, and if you have a case,
2 years.
See, the settlement cannot be taken cognizance of at this stage. If it is a matrimonial dispute and all, one can think of, because to save the life.
Compromise at any stage.
But these are the offences.
But this is a fact. How admit ନାହିଁ. ତାଙ୍କ ଭିତରେ ଆଉ କିଛି problem ନାହିଁ.
Problem ତାଙ୍କ ଭିତରେ ନଥାଇପାରେ.
The only problem, my lord, petition number 1 and 2 is a government servant. If conviction stands, they are entire pension.
That is the consequence. I know that consequence, but it is a 436 and 506.
My lord, PW1 is a hostile witness. PW2 is also hostile witness.
See the
Informant.
settlement is neither here nor there.
My last date also.
Show me some judgment on the settlement in these kind of offences.
Both.
After 2 courts have convicted you, I can set aside. Only on the ground of settlement.
And not only ground of settlement.
The merit-
merit भी
then settlement is neither here nor there.
I
Only settlement in the matrimonial disputes, 498 and all. If the settlement is there, the court can take cognizance of that fact and set aside the.
Informant is also part of the family, my lord. ସେ ଗୋଟେ family ମାନେ ଗୋଟେ ବଂଶର
The nature of offense is more important.
decision ତ ଆରଥର କହିଥିଲି decision ପାଇନି
କାରଣ କି ଆଣନ୍ତୁ ତାହେଲେ ଯାଇକି ଫେଲ ହୁଏ ପୁରା otherwise
There are.
ନାଇଁ my lord can see
142
merit ରେ ବି କିଛି ନାହିଁ my lord can see the learned trial court illegally convicted the learned additional discharge and session judge Athagad also illegally confirmed without considering only mechanically confirmed.
Trial
No
court
evidence.
judgment paragraph 9 very clear, my lord.
Judgment is material, but evidence evidence the hostile.
Judgment, my lord, evidence has been verified, my lord. As per Schedule 6, the informant, the material eyewitness are the daughter and his mother. In the cross-examination, he had stated that when they came outside, he found that half of one of his room had already been burnt, and his mother, Kausalya, and daughter, Tofani, came with his outside, and they had already woke up before him. Although the said Kausalya has not been examined, but the daughter Tofani was examined as Schedule 7. She stated that about 6 years back at about 12 midnight, the incident took place in the village, Berana. At that time, of incident, she was unmarried and she, along with her parents, 5 other sisters were sleeping inside the house. She claimed that her grandmother was also sleeping in another room, but feeling the sensation of heat. She came out and her grandmother also found her the backside of the followed her and in the backside of their house. They found the accused Pandita and a Vaida setting fire to their house. While they,
you know,
ସେମାନେ ଭାବୁଛନ୍ତି they are ଅନୁମାନ କରୁଛନ୍ତି.
I saw.
They found.
Though evidence is not admissible in the ସେମାନେ କହୁଛନ୍ତି ନିଆଁ ଗରମ ହବାରୁ ଆମେ ବାହାରକୁ ଆସିଲୁ. ସେ କହୁଛନ୍ତି ଆମେ ଦେଖିଲୁ. Main case କହୁଛନ୍ତି କଣ ଗରମ ହବ.
You have burned and when they felt the heat, they came out and saw that doing it. That's what the evidence is. And 436 is life imprisonment.
My respectful submission to my ନାଇଁ life imprisonment ଯଦି 2 ବର୍ଷ କାଇଁ କଲେ life imprisonment. My respectful submission ଯୋଉ ଘରେ ଶୋଇଛନ୍ତି ସେ ଘରେ ନିଆଁ ଲାଗିନି. ତାଙ୍କର ଯୋଉ ରଖନ୍ତି ଜିନିଷ ପତ୍ର ଯିଏ ଇନଭିଟରୁ ପଡିବ ସେ ତାଙ୍କ ନିଜ ଘରକୁ ପଡିବ ଯୋଉ ରହୁଛନ୍ତି ପାଖ ଘର ଚାଳିବାକୁ କାଇଁ ପଡିବ ଘଷି ଗୁଣ୍ଡା ରହୁଛି ସେ
Logic will not lead you anywhere.
Witness ଯିଏ କିଏ
How to doubt this evidence?
ନାଇଁ all other independent witness hostile ଯିଏ ଆଇ ୱିଟନେସ୍ କହୁଛି ସେ ଝିଅ ଫ୍ୟାମିଲି ମେମ୍ବର ଡ୍ୟୁ ଟୁ ଏନିମିଟି ଫଲ୍ସ ଏଭର ଅଫ୍ ଦ ଲଜ୍ ନାଓ ମ୍ୟାଟର ଇଜ ସେଟଲ୍ ସେ ଆଉ ସତ କହିବେ
ସେ ସେଟଲମେଣ୍ଟ ଦେଖନ୍ତୁ କିନ୍ତୁ
ମୁଁ ମୋର ତାଙ୍କର ବାଡିଆ ବାଡି ଭାଇ ଇଣ୍ଟେଲିଜେନ୍ସ ଗୋଟେ ଆଡଜର୍ନିଂ ଟେନାଣ୍ଟ କଳି କରିବାରୁ ଆମେ ଫଲ୍ସ କେସ୍ ଦଉଛୁ ଆମେ କଣ ଆଉ ସତ କଥା କହିବୁ ମିଛ କହିବୁ ଆଇ ଇଣ୍ଡିପେଣ୍ଡେଣ୍ଟ ୱିଟନେସ୍ କାନ୍ତି ଏଥିରେ
You show me your 300.
No eye witness, independent witness, all the good.
Show me your 330.
ଦିଟା eye witness ଥିଲେ PW1 and 2 they are declared as hostile ସେମାନେ କହୁଛନ୍ତି ଆମେ କିଛି ଜାଣିନୁ ଦେଖିନୁ ତେଣୁ ତାଙ୍କ ଝିଅ ତାଙ୍କ ସେ ନିଜେ କଣ କହିବେ କୌଣସି ତ ଶତ୍ରୁତାରୁ ଫଲ୍ସ କେସ୍ କରିଛନ୍ତି ନିଜେ ମାଇ ପ୍ଲିଡିଂ ସୋ ବୋଥ୍ ଅର୍ଡର ଇଜ ଇଲିଗାଲ ଆଣ୍ଡ ଆର୍ବିଟ୍ରାରୀ solitary witness ଉପରେ କନଭିକ୍ସନ ହେଇପାରେ honorable court better known to me several decisions solitary witness ରେ କନଭିକ୍ସନ ହୁଏ ନା ପୁଣି witness ଯେ ନିଜ ଝିଅ ନିଜେ ବାହାର ଲୋକ କିଏ ଦେଖିଥାନ୍ତି କହିଥାନ୍ତି କି ଆଉ ଯଦି ଜଣେ ଘର ଲୋକ ପୋଡା ମାରିବା ପାଇଁ ଇଣ୍ଟେନସନ ବ୍ୟାଡ ସେ ନିଜ
Show me the evidence of PW6. And read it.
ନିଜ ଲୋକ ମାଇଲର
କିଏ ଆସିବ ରାତିରେ କିଏ ଆସିବ
You have to demolish this evidence.
My respectful submission to my lord evidence ତ କହିବି ଦୁଇଟା କୋର୍ଟ କନଭିକ୍ସନ
And
କରିବି
in general things you don't say.
ନାଇଁ ଗୋଟେ ୱାର୍ଡ
Always
ମାଇ ଲର୍ଡ ଯିଏ ଘର ପଡିବ ମେନ୍ ଘରଟା ପଡିବ ଶତ୍ରୁ ଯଦି ମାରିବା ଉଦ୍ଦେଶ୍ୟ ଥିବ
I don't know.
ଆଉ ପାଖ ଘରଟା ଯୋଉଥିରେ ଗୁଣ୍ଡା ଖସି ରହୁଛି କାଇଁ ପଡିବ
I don't know why.
ସେ ନିଜେ କାଇଁ ନ ପଡି ଦେଇ ଡାକିଦେବେ ଲୋକକୁ ଦ୍ୟାଟ୍ ଇଜ ଅଲସୋ ଡାଉଟଫୁଲ ଦେयर ଆଇ ୱିଟନେସ୍ କେହି ନାହାନ୍ତି ଇଣ୍ଡିପେଣ୍ଡେଣ୍ଟ ୱିଟନେସ୍ କେହି ନାହାନ୍ତି
that is not their claim before
ଆରେ
the
ଆମ
trial court of the
ଆମ
appellate court.
ଇଲେକ୍ସନ ରେ ମୁଁ ଥିଲା ବେଳେ
Show me your 313. What you have said.
candidate my
Show me your 313. What have you said? Cross implicated. What have you said? Defense evidence. Statement of accused.
DW1 my lord
Statement of accused.
DW1 ସେଟା ଆମ ୱିଟନେସ୍ ଆଉ ସେଟା ମୋ ପାଖରେ ଆଭେଲେବଲ ନାହିଁ
Sir, you see, I'll tell you one thing. You have been convicted by two courts.
Two courts.
So now read the evidence and tell me these evidences are not
Evidence pilot
clear.
PwC जोड़ा भाई
And giving a logical answer why this might have happened, that might have happened.
my
will
my
not help
respect
you.
to assumption to my lord जानिया पे कोइली जने लोक जदि आई विटनेस नांती शत्रुता एडमिटेड मैटर नाउ सेटल
Where is Saturda admitted? Show me.
से कहि दिन मर्डर केस हम तुम साक्षी देथिलु दे आर एडमिटेड
Sir, read the evidence.
मो रीड द
you-
एविडेंस my lord पढुची my lord kindly read the evidence of a PW2 but they PW3 evidence about it. I know the informant, I know the actual persons who are the co-villager on by the 2003 at about 12 p.m. The incident occurred in the house of the informant. At the time of I was sleeping. And due to setting fair, all the household articles
ଆପଣ ଟିକେ ପ୍ରିପେୟାର କରିକି ଆସନ୍ତୁ
There are- ପଇସା ପତ୍ର କିଛି ପାଉନି ତ ଲୋକଟା ହଇରାଣ ହଉଛି ବର୍ତ୍ତମାନ ବୁଢା ବି ହେଇଗଲାଣି
I can't decide on that basis.
ଇନଫରମାନ୍ ବର୍ତ୍ତମାନ ଖାଇବାକୁ ଦଉଛି
See, you need an acquittal for that.
Right.
For acquittal, you need me to show the evidence. I can understand probation of offender check, sentence reduced and all these things, no problem. But you want an acquittal, aiming at an acquittal, you have to make out a case because you are convicted by two courts. I can't record because tar chakri nahi, ye nahi, che nahi. Those things are neither here nor there. On that basis, I can't acquit you. I have to write a judgment for acquittal, disbelieving two courts. The findings has to be reversed. Unless you tell me the real evidence, what are the evidence which supports you? And the hostile witnesses, the testimony of hostile witnesses can't be in the dustbin. You know that.
That is double.
You have to see
Either side.
to what stage they become hostile and which part is hostile, which part is not. All these things you point out. You point out so that I can, if you have a case of acquittal, why not? You will be definitely acquitted. Show me 1-2 points where you can be acquitted. I'll ignore the prosecution's argument. I'll simply acquit you. You assist me, give me 2 or 3 clues where I can acquit. I'll not, I'm making you sure I'll not hear Mr. Ragada, I'll acquit you. But show me something.
My two assumption, my lord. Admittedly, there is no independent eyewitness. One thing. Second, enmity proved because there are
you say.
witness on the evidence of
Then you search there. You take time and read it and come. Don't casually do it. Otherwise, I'll have to unnecessarily dismiss it, the petition, then you will be in trouble.
Okay.
Find out 1-2 points, solid point,
My
on the basis of which I can doubt the PW6. If the PW6 goes, then you have a case.
lord.
And doubt, read the PW6 statement and try to create a doubt on that. So that you can succeed. And I can reverse the finding of both the courts on that basis.
My lord.
Yes. And
Any supplementary list?
Huh?
Supplementary.
Supplementary, let it be supplementary. But come with judgment. The
My lord.
settlement will not help.
My lord.
Yes.
Item 20.
And even if you can get some judgment that in these kind of cases, if the parties have settled, they are family members and they have settled, the court can take a lenient view.
My lord.
Even to that extent, if you can get judgment of any High Court or Supreme Court, I take cognizance of that and try to pass an out. Yes.
Item 20.
20 might not pass over.
Yes.
21.
First time. Non-APS. Non-APS.
21, my lords, Mr. Mishra was appearing last time. In the morning, we met on the corridor, so she was ready with this appeal. So I'll inform him so that it can be taken up at 2 p.m. It was specifically fixed to be taken up for hearing today. He made a mention last week.
21, huh?
Yes, my lord. He made a mention last
Pass
week.
over that.
Yes, pass over.
22.
22 already adjourned, my lords.
I'll just resume the court.
The first one, that's 59.
You are, okay.
59 of 2011.
Suresh Chandra.
Yes.
Now, the facts of this case are like this.
Yes.
There's an IRDP scheme which wanted to help small enterprise. That is, they under the scheme, 8,000 rupees was given as loan for small shops and rupees 10,000 for bricklane. Now 389, 387 beneficiaries were identified in the Rayagad block, the Koraput district.
Okay.
Now, this as per the scheme, the BDO and the ABDO,
Yes.
they sponsored the names to the bank of the beneficiaries. Now, thereafter, the branch manager submits a subsidy claim to DRDA,
Okay.
which is countersigned by the ABDO. And thereafter, this field supervisor verifies the loan documents. And thereafter, the loan is disbursed. Now, the disbursal of the loan, that is also attested by an officer known as the progress assistant. Now, I was the progress assistant.
You are the progress.
I am the progress assistant.
There are as many as 5 accused.
5 accused. But by the time the charge sheet was filed, the BDO and the ABDO were dead. Even though they were materials against them, but they were dead, and hence no charge sheet could be filed against them. The charge sheet was filed against the branch manager,
Yes.
the
Field officer.
The additional WEO, and the village level worker, besides the appellant who is the progress assistant. Progress assistant. Now, charges were framed under section 13(2), read with 13(1) C of the Prevention of Corruption Act, 409, 407, 477, read with 34 IPC against these 5 persons.
Yes.
Now,
this appeal is first appeal is for this progressive assistant.
Yes.
Progressive.
What about the other 2 appeal?
My lords, the appeal 18 of 11 is for the branch manager, KPG Bank, and appeal 13 of 11 is for the field officer, PL Bari.
Let's see. This is Suresh Mishra.
Yes, he is progress assistant.
59 of
59 of 11.
59 of 11. And
18 of 11, my lords, is BK Mahapatra.
1811 Bipin Mahapatra.
BK Mahapatra. He happens to be BM of the KPG Bank.
18 of
11.
Okay. And
13 of 11 is PL Barik.
Padmalochan.
Padmalochan Barik. He happens to be the field officer.
And what about the other?
And other accused persons.
There are
only
other
3 appeals.
2 accused remain.
Manas, they were the ABDO and BDO.
What happened to their appeal?
no, they are dead. They were dead before the charge sheet could
Before
be
the
filed.
time.
4 and 5 dead
Dead. Died.
during the trial.
Yes, ma'am.
During trial they died.
Yes, during
So,
trial.
so therefore there are 3 appeals.
Therefore, there were 3 appeals.
Yes. Yes.
Now, this prosecution was launched on the basis of an incomplete investigation. It was based on just preliminary investigation, the prosecution was launched, and that your lordships will get from the deposition of the investigating officer at page 158 of the paper book. Hmm.
Huh? There is a paper book, we give it paper book, unnecessary writing. Yes, 158. Yes.
Now kindly see, on 12/1/94, I was the Inspector of Vigilance, Parla Community. On that day, I submitted a written report to the SP Vigilance Barampur against so-and-so, so-and-so, so-and-so for conniving together and misappropriating subsidy of rupees 52,000 by maintaining false records of payment to 56 beneficiaries. Now, thereafter, your lordship sees paragraph 2.
Yes.
As per my FIR, accused SC Mishra, progress assistant, has signed a disbursement register as a token of their beneficiaries' presence at the time of payment. I have only presented FIR after preliminary inquiry, but I have not conducted any investigation.
Yes.
So no investigation was done. Only on the basis of a preliminary inquiry, this prosecution was launched. Now, out of the beneficiaries, only 2 beneficiaries have been examined. They are PW 13 and 14.
Yes.
PW 13 and 14, can we see their evidence?
Page 154. 154
154
months.
Yes.
Now, cross-examination, para 2. My name is Lakshmu alias Lakshmi Maji. The population of village Gona is 1,000. There are persons, namely Lakshman and Lakshmi in our village, having their names and their father's name as Lakshman. Our village have a loan from KPG Bank Raigad. They are also repaying the same in time. Half of the people of the village. So what is important is
BPL card.
Whether he was really the benefit, because they are persons of the same name. Because he says the signature is not the signature in the disbursal register.
Right.
But he says that yes, there are names, similarly named persons and father's name also same in the village. And there are disbursals of loan to my co-villagers also. This he admits.
That receipt might be belongs to the other lecture. Other lecture maybe.
It could
Not
be the other Lakshman. That has not been and in fact, FIR has been lodged saying that he belongs to, if your lordship sees the FIR, page 61, the FIR, that this actually Lakshman to whom the loan was disbursed is of village Mohonda. Paragraph
16, 61, my lord, second paragraph.
Second row. Yes.
In letter number
Lakshan Maji. No.
So and so, all of village Mohonda. Kindly also take note of the name. The other
Gangadhar Behra, both from Gona. And
they are
Lakshan
from
Lakshan Maji is also Gona.
Gona.
Of Gona.
Gona.
Yes. He's from Gona.
They are from, these witnesses are from Gona. Loan was disbursed to a person in Mohonda.
Where from you got it that?
FIR?
No, where is that?
Page 61, para 2.
Para 2.
In letter number so and so dated 9/11/91.
Lakshan Maji, so and so, Maji, village Mohonda.
And the other witness is Sangram Suri. He is also of village Mohonda.
And this man is from Gonda.
And this man is also from Guna. And PW 14 is also from Guna.
Also letter number that has been marked, that in last second para first 4721 of 9/11/91.
You are referring to the FIR?
Bipin Kumar Mahato.
No, no, you are referring to the FIR.
Yes.
Yes. Where is that?
That
Letter
is-
number.
That has been exhibited as 33/2. That is also disclosed that he belongs to village Mohan. That is the letter.
Okay, that your case is the loan disbursed to the
Persons of village
persons of
Mohanda,
Mohana.
but examined,
Gona people were
Gona people were examined.
Names are similar and father's names are also similar. That's
Similar.
what you are saying.
Yes.
So therefore, the two
That is
witnesses.
also different.
Therefore, the two witnesses, that PW 13.
Both are of identity is not that of the loanee.
PW 13 and PW
14.
14.
Next page. Radhikun.
Both of them are not the real beneficiary.
No.
Because they belong to Gona village.
They village belong to
Name also differs. He is at PW 13 is a Lakshmi. Lakshmi, here affair is a Lakshman.
Lakshmu. Alias Lakshmi Maji.
Yes.
Lakshmi. ସେଠି ତାର ଦେଖନ୍ତୁ ତା ନାଁଟା ହଉଛି actually FIR ଇଏରେ ଯଦି ଦେଖିବେ ତା ନାଁଟା ହଉଛି ଲକ୍ଷ୍ମଣ.
Lakshman. Okay. And PW 14 just see.
PW 14 ଦେଖନ୍ତୁ ସେ ହଉଛି ଆର ସଂଗ୍ରାମ ସୁରୀ. Sangram Suri is also from Mohanda, as your lordship has seen at page 61 FIR. Now he says in cross-examination, I always reside in village Guna.
They have taken loan in the year 2000 and
I always reside in the village Gona, but he doesn't say that I am not belong to that place. Maybe staying in Gona.
But
that is village Mohanda. This is Mauja Gona. They are not saying about the same Mauja.
Mauja Guna para ଲେଖା ହେଇଛି ଉପରେ.
There is distinction between village and Mauja man.
ନାଇଁ ନାଇଁ Mauja ଆଜ୍ଞା ଉପରଟା ଦେଖନ୍ତୁ constitutional ମାନେ ଯୋଉ witness ର ଉପରଟା ଦେଖନ୍ତୁ ତ my home is at Mauja Guna.
Mauja Gona man.
Guna.
मतलब Mauja and village may be different man.
ନାଇଁ ଏଠି ପୁରା village ତଳେ କହିଲା village ଉପରେ କହିଲା Mauja.
मतलब Gauna may be in the village of Mohanda Mallards.
No.
Maybe how can such an inference be drawn in a criminal prosecution where the identity itself is being questioned?
No, you read the further in the para 2. He says that I always reside in the village Gona. There are about 1,000 people in village Gona. And most of the people of my village means he is addressing to Gona.
Gona.
Yes.
My village means Gona, obviously, relatable to the previous sentence.
Yes.
Village incur loan from Raigar Bank. About see that this part of the cross examinations are not relatable at all.
He has said that I do not know anything about this case in cross examination.
Where is that? It's not readable, therefore I'm worried. Para? Which para?
Para
155.
Para 2.
Page 155 and page 157 is not at all readable.
155.
ଇଏଟା ନାହିଁ NCR ଟା ନାହିଁ.
NCR soft copy is same.
Same thing.
You have type copy.
Legible ଅଛି. ସବୁ ନାହିଁ legible.
No, ଅଛି ଏଟା ଠିକ ଅଛି ଏଟା ପଢି ହେଇଯିବ. I do not know anything
about this case. I was not examined by the IO. And he also described about the village. It will take half a day to go to the village Mohanda by bicycle.
But I do not know.
I do not know anything.
No,
nothing.
But
how to put my signature, I used to.
Anything about this case. It was not examined by IO. But I do not know, that is doubtful. This part is very. Is it? I do not know only. I is there. In between there is nothing is visible. You have written no, but nothing is visible.
Anything, nothing.
Anything is readable.
Yes.
But no, I do not, and no, this is not readable. You have written it.
Maybe
Maybe I am not saying. But
What it establishes is this.
I do not know
that there is
about this case.
But the identification of these two witnesses, which they are relying upon,
there
is
is
doubtful.
grave doubts, grave doubts
That's
about
the
their identity.
long and short of the matter.
That is the long and short. Now kindly come back to the FIR to page 61.
Yes. Yes.
Para 2, in letter dated 9/11/91, the BDO so for loans for small shops and showed payment of rupees 8,000 each to the above three beneficiaries on 16/11/91 after adjusting subsidy amount of rupees 4,000 each against the individual loan accounts of the beneficiaries. Now on 16/11/91, this particular appellant was on leave. Kindly see page 201.
201. Yes.
He is the senior clerk. I know the accused.
Is a defense witness?
Yes.
DW1, DW4.
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 Yes. Now, I know accused Suresh Chandra Mishra, who was previously working as PA in Raigad block. He joined Raigad block on 13/2/91 as per directions of the BDO. I am referring the personal file of the accused Suresh Chandra Mishra as per direction by the court. He was on 2-day official duty at Jaipur on 18/2/91 and 19/2/91. From 20/2/91, again he went on leave till 2/10/91. The aforesaid leave was sanctioned by the BDO Raigad. Then he proceeded on training from 12/11/91 to 30/11/91.
See, this is the official.
Official witness.
Just may kindly see the cross.
Yes.
Second one.
As per the record.
After he joined on 3/10/91 till training, he was working in the office.
No, after.
As
He
per the
joined.
record, after he joined on 3/10/91 till training, he was working in the office. So training, and he was also there in the office. He was officiating his official duties. He was, though he may be on training, but at the same time, he was also officiating his duties also.
Till training, joined on
Yes.
so and so, till training.
Till training, he was
Till
working.
training. He was absent during that time. The relevant date, which your lordship sees, 16/11/91, he was not there.
When was the training?
12/11/91 to 30/11/91.
Yes.
11/91 to 30/11/91. It covers the period 16/11/91.
Yes, by 16 is on that 16 he was not there. He was working till 12. If the cross examination is also taken into account, he says that till he joined in the training. Training started from 12/11/1991,
Yes.
where the incident has taken place. From this period he was not there. Incident had taken place on 16.
Yes.
16/11. That day he was not there. That's for sure. From the cross examination also. See, read the sentence. As per the record, after he joined on
3/10/91.
See, 3/10/1991.
He joined on 3/10/91.
91 he joined.
Yes.
Till training he was working. Till training means training started on 12/11. So 3/10/91 to 12/11/91 he was working. Thereafter he was on leave. The incident, as per the incident FIR, it is on 16. After about 4 days. He was not there. Did you follow what?
I got it.
So this is not a witness who after retirement is coming and helping his colleague. It
He's
is
coming with
rather
official records and
official,
deposit.
he came and produced the official record on court summoning. That's the so these DW cannot be ignored. Yes, next.
The next submission, the last on facts that I will be submitting, there are two witnesses.
But
that
this will not inure to your benefit.
No.
You have to have separate. It is
yes.
only for this
that
witness
yes.
Now, there were two very important witnesses. One was the BDO Raigad, that is Basant Kumar Udu, and one was the OIC of the bank, head office at Jaipur, that is K. Kondal Rao. Now, Kondal Rao, these two persons, 161 statement was recorded, which explained the entire process of disbursal. Now, very surprisingly, both these witnesses were not examined by the prosecution. And this would have established.
where have you put that to IO? Show me the IO.
165 onwards.
165
onwards.
65.
Examination of the eye.
PW 17.
Yes, ma'am.
IO.
Yes.
Yes. Have you put it to IO?
Let me just check that. There is a reference to that at page 172. Exhibit 7 already marked on production. By so and so, Kondal Rao, Jaipur. Exhibit 7/2 is my signature. Exhibit so and so debit voucher. No, that question has, I don't think, not been asked. In cross-examination, paragraph 12, Your Lordship says.
Para 12.
Para 12.
Page
177. I have not seized the booklet of ITDP scheme. I have examined Basant Kumar Udu. Basant Kumar Udu is the BDO. In connection with IRDP scheme, I have examined K. Kondal Rao, Jaipur, with regard to the procedure of obtaining loans under IRDP scheme. The loans in the present case were given in shape of checks which were encashed. It is not a fact that the loanee put his signature or LTA, as the case may be, in the check register when banker's check is issued in his favor. A token is issued to the loanee on presentation of the check in the bank. On the strength of the said token, the loan obtained cash from the cash counter. Exhibit 1 shows that so and so. I have not examined the persons who had made the entries in the Exhibit 1. I do not know how the subsidy is collected, but the DRDA gives the subsidy. I cannot say if the subsidy amounts were deposited with the KPG Bank, Navarangpur. I have not examined the enumerators of the voters list. I have not verified the houses. That question has not been pointedly put.
Yes.
But the fact remains that these documents were seized from them. Their 161 statement was recorded. wherein they have stated that the role of the present appellant was that of only an attesting witness, nothing more than that. And as your lordship has seen from the entire process of disbursal, his role is that of an attesting witness. I'll rest my case by placing just one judgment of the Supreme Court. This is criminal appeal number 1587 and 1588. I think I've supplied the copy because this was heard a judgment at Sibo Court.
Criminal appeal number?
Criminal appeal number 1587 and 1588 of 2019.
You have a written note also.
Yes, and, in fact, the hearing was my part of the hearing was completed.
Okay.
But the State Council had taken time then, and then.
I have 1586. That is Srinath.
M. Shrikant. M. Shrikant was the state of Telangana.
Which paragraph?
Para 7 first. Is the further case of the complainant, the accused number 1 posing himself to be the owner of the premises on the basis of the alleged oral will and deed of confirmation created a registered lease on so bearing document number so permitting accused number 4 to sublease the land in favor of accused number 5, HPCL. Accused number 6 and accused number 9 are employee officers of accused number 5, HPCL, whereas accused number 7 and 8 are the attesting witnesses. Now, I will then take your then take your lordship to para 18.
18.
It is further the case of the complainant that accused number 1 created a will in Urdu purported to be executed by a grandmother, bequeathing the property in favor of her parents, namely so and vesting the remainder to accused number 1. The said will is created on non-judicial stamp paper of Nizamat Jung and was allegedly executed on so according to the complainant. Accused number 1, a brother, had created another forged and fabricated document styled as deed of confirmation Hiba Bil Musha, confirming oral gift to accused number 1 and also recording handing over of the physical possession. It's a case that on the basis of these fabricated documents, accused number 1 posing himself to be an absolute owner of the property executed a lease deed in favor of accused number 4, the appellant so. It is further the case of the complainant that thereafter accused number 4 executed a sublease in favor of accused number 5, HPCL, represented by accused number 6 and 9 within a period of 2 months. That is on 31/29, and that accused number 7 and 8 are the attesting witnesses.
Yes.
Thereafter, para 26. Insofar as the criminal appeals arising out of the special leave petition filed by the original complaint is concerned, we absolutely find no merits in the appeal. The learned single judge has rightly found that there was no material to proceed against accused number 5 HPCL and its officers 6 and 9, as also accused number 7 and 8, who have been roped in only because they are attesting witnesses. The learned single judge has rightly exercised jurisdiction under section 482. No, there is. Witnesses. So attesting witnesses cannot be held to have any complicity in a criminal.
That is your proposal.
That is that is all. And I have also given a list of witnesses which are relevant. That is 13, 14, 15, what I've read out to your lordship.
But in your written note, you have not said those. Will you file a improvised one?
I can do that. I can. Now, your lordship takes this.
And
this-
may I suggest one thing?
Yes.
Since you have taken me to the entire record,
Yes.
your junior can very well assist.
Mhm.
Wherever you read it out,
Just prepare a
highlight that
synopsis
pattern and give it so that it will be easier and page also. In
Absolutely.
paperwork page. So immediately I can refer. to it.
Absolutely. Absolutely.
That will
I'll
be-
have that done. I'll have that done by Monday.
Let him let her do and show it to you. so
Yes.
that-
By Monday we'll file.
And the judgment also, madam.
This judge.
You do properly, it will be a reflection of your ability and your senior's settlement. He'll settle it, but he may not have that kind of time. You have to do it. This is your job. Highlight the portion which you have read and give your comment, note, comment.
Yes.
Suppose you, two witnesses you have pointed out. They belongs to village Gona and FIR says they belong to this. Likewise, you give the notes. So that will be easier for to connect. Yes. Yes, sir.
Well, I may be excused.
Yeah, definitely.
Because, my learned friend will be here.
Yeah. You note down if any question comes, then you have to tell him. Yes.
Here he has stated the control card.
You are for, sir? You are
B.
for
Mahapatra.
Padmalochan?
No.
BK Mahapatra.
Manager.
Mahapatra.
The branch manager of KPG.
This is Mr. Mukherjee.
I have been also charged 409, 477A and 34. And he has been convicted on the basis of
1 minute.
PW 13 and 14. And also pay fine of rupees 5,000. In the above appeal, the allegation of misappropriation of subsidy amount by constituting false loan records.
Yes.
Amount of 11 beneficiaries of 52,000. But he has only found 8,000 only on the basis of PW 13 and 14. And others beneficiaries, that has been reflected in FIR at page 62.
Yes. Yes.
62 second para. Inquiry revealed that none of the above 7 beneficiaries, I am including here, in page 61, myself, the Bipin Mahapatra and others, 3 others. Inquiry,
You are confining your argument to Mahapatra only.
The branch manager.
Sabu cover kariyo khali majhire tike all.
But you are appearing for
Yes,
Mahapatra.
appearing Bipin Mahapatra. Inquiry revealed that none of the above 7 beneficiaries. Beneficiaries means Sangram Suri, Lakshman Majhi and others. Here they have described. And
all the 7 described?
Amyakanta Biswas, 7 beneficiaries.
Out of them, two were examined.
Yes.
Yes. Is existing village, the voter list and the statements of local people. I'm reading out that para only. Local people and Sarpanch confirm that the names of the above beneficiaries are fictitious. Here I am also to that Lakhimaji and Sangram Suri, jo PW 13 and 14, on which basis I have been convicted. They have said that they are fictitious. It has been further ascertained that the loan records in respect of the above 7 beneficiaries were maintained by the PL Bari and FS of KPG Bank, Raighar. Now the photographs of beneficiaries Sangram Suri, Amyakanta Biswas and Lakhimaji are missing. And the case record of beneficiaries, Bhattam Kolar, Chandra Gupta and Durjadhan Majhi and Lochu Majhi are also missing. The control card on the basis of the loan sanctioning documents, there is no photograph. Only the control card I have.
You are the manager, bank manager.
Yes. Only I have only worked out only after the identification, signatures, and thereafter I have signed. I have no.
But you being the bank manager, it is your responsibility. You are the head of the bank.
Responsibilities come to my.
The missing, that is why the prosecution says that these are missing. That indicates that at your instance it is missing. That's what the indication is.
In fact, the case records are also missing. Case records are missing.
That is the indication.
And in some case records, the photos were missing.
Yes, some cases.
And false.
I am giving a one control card. just like another Omiyakanta Viswas. I have no other Lakshmi Maji and control card kebala daskatti achi, tipo achi, no photographs, others.
So how during your tenure this has happened?
That has been done by I have stated in my statement, my law, that is evidence.
Page 67.
How this has happened? Without photograph, without any identification, nothing is there. And you disburse the money, being the manager.
I am 193 page. I am reading out that.
193.
193.
Yes.
From today, I am in charge of branch manager of Raighar Utkal Gramya Bank.
This is which witness? This is DW?
He is DW
One.
one.
Branch.
DW1.
That is 197, right? The Bipin Mahapat, the statement of Bipin Mahapat.
197.
Yes.
Okay. You have examined yourself as a witness?
Yes.
Yes.
Okay.
DW3.
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 DW3. I am reading out. I was appointed by the Board of Directors, Koraput, Panchayati Gramya Bank, Jaipur, on 12/1/78. In the year 1991, I was serving as a branch manager, KPG Bank, Raighar, having 3 field officers, 6 cashiers, 1 passing officers, and 2 messengers. The scheme loan, along with applications, are received from the block, which were received by the receiving cashier. In all the scheme loans, provisions for subsidy was available. As per the circulars of the bank, there was guidelines to deal with the subsidy by circular number such and such, dated 16/5/91. Exhibit B is the said circular. We used to follow the manual published by the government department and rural department, Ministry of Agriculture, government. After receiving the loan application from the block, those will be given to the respective field officers of their areas, who will visit the villagers before sanction of loan and will scrutinize the viability of the scheme
and documents
and prepare the required documents, and after documentation.
Yes. Thereafter, the document will be submitted to the branch manager. You are the branch manager.
Yes. Submit to the
And
branch
basing upon
manager.
the recommendation of the
Based upon
branch
recommendation on, yes, in the absence of branch manager, the passing officer.
See, it has gone to, you are the head of the institute. Photograph is not there or there, all these things is your responsibility.
Yes.
What are you trying to make? This is worse for you.
Everything they have identified, they have done, everything has been done.
You are the head. You are the head. Will you not see the proper form is there or not? That is why the senior most officer is the sanctioning authority. You are the bank manager.
I am saying the identification. Who has identified those persons?
Where is the photograph? Where is this file? There is nothing.
There is
Still you are sanctioning.
And,
You are the supervising
and
authority.
Lakshmi, kindly come to page 194 for a moment. It is their witness, DW1.
Yes.
What he says about the modus operandi of the entire processing of the file.
Yes.
194, para 2.
Yes.
Lordship, have it, minutes.
194, para 3.
Para 2 minutes.
Para 2.
Yes.
Yes.
After the
loan application,
the concerned
the concerned field officer
verify
will
the
verify
genuinity
the
of the
genuinity
beneficiary.
and beneficiary.
After verification of the documents at the bank, the branch manager will sanction the loan on the recommendation.
Yes, I am.
That's right. But
Yes.
therefore, while sanctioning,
Yes, he has
you
to
must
go
see what are the
scrutiny.
documents placed before you and not that sanctioning you so monotonously. You are the superior authority over the field officer.
But
the field officer is this is vicarious liability.
The letter which has been marked as exhibit 33/2, that has been sponsored by the BDO and others. They have only recommended the name. They have not sent the photographs and others.
Then you should reject it. You would not have sanctioned it. It is incomplete form. That is why the hierarchy is maintained. If the clerk has sent something by taking money or bribe, whatever, The senior officer has to look into it. That is why the hierarchy is maintained. You are the top boss. If you have sanctioned, then the liability is on your head. What to do? Give it. Liability is on your head.
Yes.
So these witnesses, and you have examined yourself, makes your case worse.
No, I have to say that that has been done by
Somebody else. I was the sanctioning authority. I have no responsibility. That is what you are arguing.
in the instance of BDO had sponsored the loan application of the beneficiaries. And the bank mentioning code number, name of the
You tell me one thing. If the video verifies everything, you have to give it. You have no option. You show me anything on record.
It is the scheme, my lord.
Where is show me the scheme? That once video approves it, you have no option.
Yes.
The bank has to give it.
In fact, your lordship may kindly come to page 196. Is their witness, DW2. DW2, page 196, the cross-examination part. The first line.
Yes.
The checks were issued by Field Officer P.L. Barik, which was passed by the BM.
That's right. Same
He was
thing.
at the helm of the affairs.
If you can show me something on record that once the video and everybody has,
That I have to gone through the scheme first.
that is your case.
That is.
Otherwise, you are in.
No, other points are there. On the basis of the witnesses, they have accused me.
No. See, insofar as Mr. Mukherjee's client is concerned, he has pointed out to two vital things. First vital thing is
Absence of that.
he was absent,
Yes.
and a official witness was examined.
Yes.
And
on
he
that
was,
particular time.
and he has
stopped.
only attested it.
Whatever.
This is what-
And second is he's an attested witness.
Yes.
He relied upon some judgment. And third, he says that the two witnesses on the basis of which
Different village
he has
and
been
Mauja.
he has been roped in
Yes.
are the doubtful witnesses because their village and everything identity is doubtful.
Doubt.
These are the very
Basic.
clear cut.
I'm also basing, I'm
uh,
also basing on that PW 13 and
That's
14.
right. That is any to your benefit.
Yes.
That is only to benefit. But the other witnesses, your own witnesses, is bringing you inside. You please see the scheme.
Yes.
And tell me, if in the scheme it is written, if the video and all have approved it, bank has no option only to
Pass it.
pass it. If you do that, then you are out. Otherwise, you are in.
Here, another point is the sanctioning authority. My appointment is like this. The board of directors of that is the that has been marked as exhibit.
Yes. Who is the sanctioning? Who has given the sanction?
Sanction has a chairman of the board of directors. But I have been appointed by the board of directors, not by the chair. That is the appointment.
Then who will give the?
And the board, entire board.
Board has to.
Yes,
Board has to.
yes. That is the appointment letter. You have to lots.
But-
that has been marked.
Who has appointed you? Board. Who has signed it? Chairman has signed it.
Chairman has signed it. But that is the. I'm reading out that.
See, the board has appointed you.
On the
and
concept-
chairman has issued you the appointment letter, and the same board, the same chairman who has issued you the appointment letter has given you the sanction. What else?
They have not given in the board meeting. They have personally himself has.
So show me what.
Yes, that
Show
is
me the
the-
question. Show me the question you put to the sanctioning authority. Which witness is
Yes,
that?
my lord, I'm placing the
Evidence, yes.
witness number 20 at 183 page.
183. 183.
Yes.
Yes.
On 16/6/98.
One
Lord,
minute,
you got-
1 minute, sir. Yes. Yes.
I was working as a chairman, Koraput Panchayat Grama Bank, Panchavati Grama Bank, Jaipur. On that day, vigilance DSP appeared before me and produced copies of FIR, case diaries, seizure list, and other documents, and discussed with me about the facts and circumstances of the case appearing against the accused B.K. Mahapatra, ex-BM of KPG Bank, and P.L. Barik, ex-field officer, KPG
Yes.
Bank. I
Record
went
it,
through the
enter it.
documents produced by the vigilance DSP and applied my mind and accorded sanction for launching prosecution against the accused persons.
Come to the cross examination.
Here the appointment letter I am reading out now. With reference to the written test and interview held by 9th January 1977 on 30/4/77 respectively, as there was no vacancy in the post of field officer in the bank at present, the board of directors, that is the important, the board of directors of the bank have decided to offer you the post of field assistant in the bank in the following terms and conditions. The board of directors, not the chairman himself.
Who is your disciplinary authority? Board or chairman?
That's board represented by chairman.
Board represented by chair.
You have you put a suggestion also. She denied the suggestion.
On which?
See the cross examination.
185 para 4.
184 para 2.
The board of directors are sitting once in a quarter. The board of directors never takes decision of appointment
Para 4
policy.
is more clear.
It is not a fact that the board of directors appoints staff of KPG Bank. It is not a fact that I was not the discipline. So,
the suggestions were also put to him and which he denied. Yes, next point.
Lord, as far as sanction is concerned, your Lordship knows Matthew Varghese case.
here the
Paul
bank
Varghese,
has not lost
2006.
anything.
He has to
Bank has not
establish.
lost anything. He has got the money, subsidy amount and others. That is not lost to the bank.
Yes.
And that the subsidy amount, everything has been paid.
Have you prepared any written note?
Yes, I have prepared. But I have to say on that Monday, everything. I have prepared that.
You prepared properly because you have a difficult case.
Yes.
You have to. No. You keep it with you. You improvise it and read the scheme and try to point out from the scheme also.
I have to verify the scheme.
Scheme
Whether I
and
have a
other
scheme-
points the point which you have canvassed is not appealing.
No, I am basing on the statement of PW 13 and 14. PW 13 and 14 are not the persons of Mohanda. They are from village.
That he has
That
argued.
he has
That
done.
is one point which is little lean towards you.
No,
The other points are
the persons actually named Lakshmi Maji, but here I have been the PW in affair, in control card and others.
there are other documents are also. Even if the oral testimony of these witnesses are taken out from the record, even then the documents are staring on the
Only my fault is that I was the branch manager at that time.
Not fault, you have
Benefited. Rather benefited. If you in fact, exhibit 22, if your Lordship may see, that is the loan disbursement register. Exhibit 22.
So therefore, see, oral testimony they can get out.
Yes, records are there.
But the records are there. How
Very
do you-
indicative matters.
Even if you don't believe these two witnesses, even then, there are material which stays on the page.
That I understand because of the responsibility of a branch manager.
So therefore you have to little labor hard to get out of the exhibits also.
Exhibit 22 at page 41 and 42, all three appellants have put their signatures for disbursal. of
I
loan.
think you need little more efforts to put in. Yes, who is for Padmalochan?
PL Barik.
You are working as Field officer of the.
Field officer.
Field officer. Oh. He says that because of you, he is in. You have done all mistake.
Only to the, only
Yes.
to, at the time of a sanction of the loan, I have to assist the BDO for a
You say
beneficiary.
video has done. He
No, no,
says
no.
that
This
you
is
and
the-
video have done.
As per the
The
scheme.
all onus is being shifted to A BDO and BDO.
Because
Reasoning they are,
This is
they
not
are
the
taking.
case.
Exactly.
As per the scheme, my lord, the sanction is to be, government sanction, loan is to be sanctioned by, and the approval is to be made by the BDO, taking care of the same through the Gram Sabha, my lord. And at page 75, the 75 cross examination made to the IO, Inspector of the Vigilance Department. He has already stated that the procedure under which the loan is to be sanctioned, my lord. 165, 75.
175.
My lord. The BDO will prepare the list along with the loan applications and forward the same to the bank. The BDO who attended the Gram Sabha will submit the loan application. Our case, I am the field officer. I have to only to give my witness to the beneficiary who have to get the, who have to receive the loan, my lord.
What is the requirement for a documentary requirement for loan?
Loan, my lord, they have to,
Without photograph, without anything.
they have to submit all the documents before the.
What are all the documents?
All
You
the
are the field officer, you are supposed to verify whether genuine people are there or not.
No,
That is after all the bank's money.
My lord, loan has to be approved through the BDO. The applicant, the beneficiary has to submit all
And
the
if the
documents.
loan is verified by the BDO, if the documents are insufficient,
They have to
whether the field officer is not entitled to reject it.
My lord, we are not saying so, my lord. If the document has not been properly forwarded, then the.
That is your job.
Bank cannot be.
And the fact remains that the documents were not properly filed
At this
and loan is sanctioned.
Our case is that
Madam, at
those
least-
beneficiaries who has availed the loan on, namely Lakshman Manji and those two persons.
So that
They
point
will
is
have
there.
to-
That is not the only point on the basis of which you could get.
As far as this appellant is concerned, my lords,
Uh,
the witness of PW11 is very important. Your lordship may kindly come for a moment. Page 150. He is the field officer.
150.
Yes, my lords. PW11.
Yes.
I was working as the field of lordship have it, my lords?
Yes.
I was working as the field supervisor, Koraput, Panchapati Gramya Bank, Raigada branch from so and so. I had verified the register relating to sanction of loan in favor of Sangram Suna, Lakshman Baji. These are
So-and-so,
PWs
so-and-so.
13 and 14. Amiya Kanta Biswas, Mr. P.N. Barik. Here, Mr. P.N. Barik, who was working as field supervisor prior to my joining, produced 3 persons and claimed that they were entitled to the IRDP loan, Integrated Rural
Yes.
Development Program loan. He had taken the thumb impression and signatures of those documents which were produced. Exhibit 12, 13 and 14 are those control cards. I had filled up the contents of the above exhibit as per the request of Mr. Barik. I have not visited village of the above persons and have not verified the other documents. Mr. P.L. Barik had taken the LTIs on the above documents when he requested me to fill up the contents.
Except
He has
filling
filled
up the sum of the column of exhibit.
Except filling up these columns of the above exhibits at the instance of BM, I have no personal knowledge regarding the other contents. Though 3 persons were present when I filled up
So
some portion.
your complexity is just
Here.
to what extent? You influence one of your colleague also to.
My lord,
get it done.
he has filled up his statement that I have filled up the entire form, my lord. And as far as
What interest you had if the video has done everything? Why are you insisting that in
No.
front of you everything has to be done? Everything should have been done before the video, not
Yes.
before you. And you are trying to portray everything has been done by video and it was
No, no,
given
no.
to me. I verified and gave it to the branch manager who sanctioned it. That's what your whole case. And you want to shift entire things to video.
No, procedure. What is
No,
the
procedure, but what procedure you have adopted? You have adopted you yourself have
Requested.
produced 2 people, 3 people, and got their signature in front of you. All these things, this job is supposed to be done by the video, not by you. This is the witness. What is the cross examination? Decline.
He's another witness. I am not the.
No, no, this is PW 11.
11, madam.
You have not cross-examined.
No, it has been declined. That is,
Everything he has spoken against you.
that is, it is accepted, madam. It is unchallenged.
If you don't cross-examine this PW, then how will you get out of it, this evidence? You have not challenged this evidence at all by not cross-examining him. This has gone on record now, unchallenged. You have very difficult case now.
I will, next date I will clarify the procedure under which the document has been produced.
Procedure is something. Procedure, see, if the evidences are staring on the face of the record, on the overall procedure, I can't ignore this evidence. These are the evidence which is there on the record, right, wrong, whatever. You have not cross-examined, you left it like that. You further get ready for that. Let them get no opportunity. They have a very, both of you have a very difficult case.
No one from village Mohanda has been examined.
See, there is only one point you are saying always, sir, but see, what are the, how will you get out of the documents?
Documents.
All the documents were generated at the instance of field officer and branch manager. And you are the people, you have sanctioned the loan.
The allegation is that we have prepared the documents and our instant that has been.
And PW 11 exactly the same thing. It has been prepared.
Says that
the field officer has prepared, given to you, and you sanction it without verifying.
On the basis of faith, on my officers, I have done this. It is on good, based on good faith.
22 is also very clear, my lords. Exhibit 22, they all have put their signatures in the disbursement register.
You have done it very casually. There are many documents also.
Yes, my lords. But altogether, there were 85 exhibits as far as we are concerned. Prosecution, we have exhibited 85 exhibits, 85 documents.
And the Mr. Mukherjee's client also have a difficult case, but he has taken a alibi.
He is only the attesting of that.
And
I have one judgment to that.
That's the advantage here, but for you it is very difficult.
I have one judgment, my lords, as far as Mr. Mukherjee's client.
When you address that, you
I will
remove that.
Regarding sanctions, so also the document which has been seized forwarded to the authority liability for
Regarding sanction, I have already placed my lord, only documentation.
Sanction is difficult in the sense the board is the appointing authority and the
Chairman
has appointed.
And representing the board members.
Chairman is appointed. If the
on the decision of the board of directors, directions, I have been appointed.
Suppose if the President of India appoints,
taken any
President of India, on the direction of President of somebody else is signing, being appointment authority, who you will bring the President of India to
board of directors, all cannot sign. Only one of them can sign.
The chairman has done it.
But he cannot take.
No,
where is the suggestion? Where is the suggestion you have put to the sanctioning authority? That have you placed all the documents before the board or not? Have you put that question? You have not put that.
That is the only question.
Very carefully seen that.
That is the only question to see whether that can be
that you should have put that question
without the prior approval of the board. This is the only one question.
That question is missing.
Yes. And your lordship
the
knows.
Council should have put that very specific question.
And your lordship knows, my lords, Paul Varghese versus State of Kerala 2006 Supreme Court. They have to, in case there is any defect or omission or error in sanction, they have to establish what is the failure of justice that has occasioned.
Prejudicial, what?
Yes,
prejudicial.
and at the appropriate stage.
And there is no specific question put to the chairman.
Sanctioning authority.
Sanctioning
Yes.
authority.
Yes.
Now you may argue whatever, but it should have been put to the witness. He would have said that yes, this is the procedure we follow. And the board of director might have told him also that you give sanction. Yes. I don't know. We don't know. So that question is missing.
That question, I also, when I am going through that,
it's very, very, very technical, but what to do? These are the cases. You prepare it. 1 week after, we will prepare and give the written submission. Thereafter, I'll hear you after completion.
Yes.
August.
Item 12.
Nobody is appearing.
Nobody is there.
Hmm? Notice was issued. Yes, Mr. Goda. You suggest somebody.
अच्छे एक नंबर प्रदीप कुमार पंडा गोटे दे देना
ହେଇଥିଲା ଆସୁନାହାନ୍ତି ଆଉ
नहीं प्रदीप पंडा में दिया है नहीं दिया
Ashwi.
আমি কে
Mr. Mishra,
Mr. Mishra, you can help us.
हाँ
What? Pursuant to the order dated 23/4/2024, notice was issued to the petitioner. Despite service, none appears. Mr. S.K. Pradhan, who was earlier appearing, has withdrawn his wakalat now. Hence, Mr. Mishra, Dilip Kumar Mishra, the counsel who is present in the court is appointed as a amicus curiae to assist the court. When do you want, sir, a copy of the paperwork? The related paper may be supplied to him within next week, anytime.
Register me directly.
Registry directly. Yes.
Next week, Friday.
His name may reflect in the process. Yes.
नेक्स्ट वीक ना
Let it be there in the supplementary small matter. Yes. Yes.
My hands up. Mr. Mishra name may be reflected.
Yes, yes, I have said that.
Item 16.
Yes.
The petition under section 457 CRPC has been rejected by the learned trial court. Petitioner has filed this revision challenging that rejection order and for release of seized fixed deposit and TDI.
What are the document or what do you want to be released under what was your prayer in the 450?
Actually, he doesn't have the brief with me. He came to me, my lords. I just wrote, did it 2
You can
lines.
read the entire
Still, it's better to start. He started that. That's a welcome thing.
No, but you should have read it. The file was there with you.
Next time I will.
Sure. Next week?
Yes.
Okay, next week. Okay, next week.
17.
Mr. Mahapatra, next week. You must give the file to your junior so that he can prepare and come. Empty-handed without file, he comes and asks for adjournment.
Yes, sir, sir. Next week.
Okay, next week, no problem. Okay.
17.
Item 17, let's may I please.
Hmm.
Let's say the petitioner has challenging the judgment, order of conviction and sentence passed by Lawrence STJM Rairangpur.
What is the offense?
That's it, 354. 354 and 448 of IPC.
Convicted in both the provisions.
Both. 15 days in 448 and 6 months in 354.
Yes. What have you done?
Let's see my
What are the allegations?
Allegation, let's say the informant feeding was feeding water to her son. So that time accused Narendra Giri snatched away her son from her lap and threw on the ground. The informant raised the holler and accused pressed her mouth and dragged her into the ground.
Yes.
Then the accused tore her sari and Then the informant assaulted by means of steel glass on the face on the accused face. Then
Who is the victim? PW1?
PW1.
Come to the PW1 statement. Let us see how the trial court deals with that.
The PW1 stated that
Hmm.
the incidents took place since years back on Saturday at about 8:30 a.m. in the veranda of our house.
Yes.
During that time, I was feeding water to my son. No other family members were present. In the meantime, accused Narendra reached there. He forcibly snatched away my son from my lap and threw him at the floor. Thereafter, she caught hold my hand and forcefully dragged me inside the room. When I raised Allah, accused closed my mouth with his hands. He dragged my blouse forcibly, for which my
My blouse
was torn.
and he led
He led
me
on the ground
on
and
the ground and opened my
sari and saya.
I tried to resist.
Resist accused and found a steel glass and dealt the accused by means of that glass. Thereafter, accused left the place and threatened me not to disclose the incident unless he will kill me.
Yes.
After some time, one Chandrika, my sister-in-law, who was the PW2.
Who's the informant? 10 days.
Informants.
Come to the cross then. How have you created doubt insofar as that incident is concerned?
Let's say after incidents, she lost the affair after 10 days.
But she says that in paragraph 5, she says that I have lost it because after my husband came, I informed him. Thereafter, I went and lost the affair. And the trial court says that it is but natural. If modesty of a woman is outraged, he would definitely tell her husband, then only the affair will be lost. The husband was not present there. He was traveling somewhere. He came after 10 days. And that is justifiable reason to explain the delay.
My point is, if the informant went to the house of the accused with her sister-in-law, and the house of the informant and the police station about 15 kilometers.
Then?
And the communication is the motorable road.
That is neither here nor there. So therefore you say that it is motorable communication was there, everything is there. Why she has not gone? That's what you want to say. She has explained because he was waiting for the husband. Without the knowledge of the husband, how can the wife can go and give a complaint against someone? He was the 10 days is explained. See, para 5, you come to para 5 of that examination chief. After 10 days, I lost information. At what is it?
At Tiring PS. During the incident, my husband
on his return,
I lost
him.
Trial courts also held that it is very natural that she would contact her husband.
That would be the obviously explained.
That has been explained. Really has been explained.
Why should we doubt the version of the victim?
Doubt, let's say,
in the cross-examination, have you elucidated anything to create a doubt in the cross? Let's see. In the cross-examination, have you elucidated anything?
After, let's say, para 11.
Yes.
Of course. After 10 days of the incident, my husband returned, and on the very day I lost information, I, along with my husband, and father-in-law had gone to the PS. I narrated the incident to the Thana Babu, and thereafter lost written information. During my husband's absence, my father-in-law looks after the family affairs. That's it. It is not affect that due to previous enmity of the accused with my father-in-law and brother-in-law, this false case is initiated on their instruction, and that to made out a case against the accused, I have purposefully submit the torn blouse and steel glass before the police, and that no such occurrence.
There was past enmity, therefore you have been implicated. That's what.
That has been denied by him.
That is denied.
It is not a
That
factor.
suggestion is there.
It is not a factor.
Yes.
Let's see, the occurrence happened in the veranda of the informant's house, which is adjacent to the village road. When the occurrence was happened with the informant, it is reasonable to suppose that occurrence must be witnessed by some person going on that road. As said, the occurrence took place at about 8:30 a.m. in the morning.
There is no eyewitness. That's
No
what you want to
eyewitness.
see. Any other point?
Another point, when the accused forcefully drag the informant inside the room, he closed her mouth with his hand and laid her on the ground and told her
To be 1 lakh liter, 50% of that would come to 50,000 liters. Duty has to be paid on 50% of the shortfall. This is in the Honorable Supreme Court's order. Your Lordship wanted to see that letter.
Yes, yes. Where is that order here?
That is there.
Yeah.
Annexure P/4, that very letter I have given. 7th of March 1990. बाहर कर देली पूरा
Memo.
पढ़ी ना रे
नहीं
से चिट्ठा में तो रिपोर्ट कर दे
1 minute there. Supreme Court order just
देखिए चिट्ठा
No, they did.
The whole issue is whether MDQ should be by the commissioner, fixation of MDQ by the commissioner is correct or not. If it is correct, then whole proceeding goes before the Supreme Court. That fixation of MDQ by the commissioner was held to be correct.
The Supreme Court is part of the
record. Yes, my page 31.
31. Yes,
Yes.
that's what I was wondering.
Page 31.
31. Yeah. Page 31. 31. Yes, page 32.
Page 32. This appeal is filed against the judgment of the High Court.
Annexure P4. This is
P4.
the paragraph.
That is the P4.
That is P4. This is P4.
This is P4.
This is P4.
7/3/1990.
What does it say?
Lord,
Supreme Court relying upon this.
On this.
This order was passed.
And quashed our the demand was passed.
So this is production
capacity
is approved by the government.
Approved by the fixed by the commissioner, approved by the government. Approved by the government. So now the question is, what should be the MGQ fixed? The MGQ fixed by the commissioner upheld up to Supreme Court, whether it is correct or the DIC certificate based on which they are prosecuting us.
Yeah, yes, Mr. Das. How will you get over this?
One just thing I may explain, because he has been giving emphasis that earlier CRLMC file was dismissed by this Honorable Court for passing of the proceeding. I had shown that order. Your Lordship has seen that that doesn't assign any reasons. Despite that doesn't, on very, very specific issue, that is only on a cryptic line, they dismissed our chair LMC, saying that, that order is here. That doesn't assign any regions. That is why your lordship also disagreed on that order last occasion. So,
That page number,
it is here.
you have not filed?
That order is filed. This is the order. It was earlier given, this is the order.
Yes.
Lordship has seen it last week also. That is in respect of one of the co-accused person, who is also petitioner in one of the cases here. He wanted passing of that proceeding. This honorable court, in fact, without dealing with any aspect, merely just by one observation, kindly see.
16, 15, 16, 11, 15. How many accused are there?
4 accused persons. One of them is the Commissioner of Excise. Now they cannot say that the lower clerical people submitted the proposal and commissioner is, they also implicated commissioner. Now that commissioner is dead, he is no more alive. So I guess that has to await. So rest 4, starting from junior assistant, senior assistant, bench clerk, all these people.
Senior assistant.
Junior section officer, senior assistant, these lower cadre.
What are you?
Oh yeah, we 4 are here.
All the 4?
That distillery licensee is here. 3 are those staff. Those who have dealt with the file in course of their official business.
Yes, sir. You just file it in a memo. This
I have filed it. With a memo, I have filed it.
It's there.
That is one.
This one?
Yes.
I filed.
Memo is there.
Okay. Yes. Yes.
My lords, in this case, my lords,
Which page this memo you
I have unfolded that. Let me again read.
Page number? Pagination for that. And this also you just attach with that. And please paginate and write there at the top. Yes. Paginate and write at the top, which is the annexure 4 to the Supreme Court, this thing, annexure 4. Yes.
my lords, in this case, my lords, I prepared a note of submission before I will not place the entire thing, my lords. I also rely.
Yes. Yeah.
I also rely to 4 or 5 judgments, my lord. I will not place all these, my lords. I'll just place few lines from 2 judgments, my lord. But your lordship kindly permit me to place the 2 important aspects. My learned friend had submitted last occasions today also, my lords. My lord, in this case, there are 4 petitions for lordship. And out of the 4, my lord, 3 are the employees of the excise departments and the excise superintendent office. And the 4th one is the beneficiary, that Mr. Jaishwal, my lords. And my lord, in this case, they have challenged a particular orders by which all the discharge application have been rejected, my lords. And my lords, they take out from all his submission, my lords, can be put in 2 categories. One, Mr. Ross said that, look, while considering our discharge application, a particular document which I placed before the London trial courts for their consideration. What is that document? The order of the Honorable Court, my lords. And that document is absolute sterling in nature, and the London trial court didn't consider it in proper perspective. 1. 2, my learned seniors, Mr. Roth submitted that all the pleas advanced on behalf of the defense, my lord, were also not considered in proper perspective. These are the essence, my lords. And my lord, entire case of the defense hinges on a particular document, that is the judgment of the order of this Honorable Court, my lords. Now, my lords, with regard to the averments, the pleas, and all these things has to be tested, my lord, on the anvil of law laid down by the Honorable Supreme Court, my lord. Now, the first question, your lordship will permit to address, your lordship, that whether an accused before the London trial court at the time of consideration of the discharge application has any right to produce any documents? The answer would be no, my lords. Why say so, my lords? Your lordship is...
So that the answer is no.
Answer is no.
Yes, answer is no.
And my lords, if your lordship permits, my lord, the second question, my lord, whether the pleas of the accused before
Are you suggesting that the document which he is relying upon, none of those documents were part of the charge sheet?
Exactly. The judgment, the copy of the orders and all these things, my lords, are not part of the charge sheet, my lord. This is a particular piece of records. At best, my lord, I can put it in the category of unimpeachable in characters, sterling in nature, my lords. But those documents cannot be placed, and whether the learned trial court was, in fact, his action, he resists the temptation of not accepting that particular order of the courts, which is a document produced by the accused at the time of consideration discharge application law. My humble submission, my lords, law with regards, my lord, I lost at the cost of repair, I place it 2 lines, my lords.
Now imagine a situation if all the documents are placed by the police, which really makes out a case. But that case is contrary to the judicial determination by the highest court. What will be the situation? Can't the court ignore all the document and give precedent to the law laid out by the Supreme Court?
Lord, that that proposition has been answered by the Honorable Supreme Court. Your Lordship may permit me to place it, my lords. At the outset, my lord, let me place at the cost of repetition 1 line, my lords.
Yes.
The same land back judgment of the Honorable Supreme Court, which emanated from this Honorable Court.
Yes.
That's a D&P party judgment, my lords. I'm just placing paragraph. I'm just placing, but at the cost of, because this is an anvil, my lords, on which all this proposition has to be tasted, my lords.
Yes.
Lords, you may, at the cost of repetition, lords may turn to para 8, my lords. I just place 1 line on each. Para 8, my lord, last line, at page 574, my lords. Last line, my lords. No provision in the code grants to the accused any right to file any material, whether material includes an court's orders, my lords, or documents at the stage of framing of charges. The right is granted only at the stage of the trial, my lords. Now, lords, you may turn to next paragraph, paragraph 18, my lords. Paragraph 18, my lords, at page 577. There also I'll place only 1 line, my lords.
18, huh?
Page 18, page 577, the last line of the paragraph 18.
The expression hearing.
The expression hearing the submissions of the accused cannot mean opportunity to file material. No opportunity to file material to be granted to the accused, and thereby changing the settled law. Even Your Lordship Supreme Court has gone a step ahead of it. At the stage of framing a charge, hearing of the submissions of the accused has to be confined to the materials produced by the police. Let's say about the documents. Even the submission of the accused counsel is also confined to the materials produced by the prosecution, that's charge sheet. Cannot beyond that. Even if Your Lordship may kindly turn to page 20, para 23, my lord. I just placed 23, 1 line, my lords. Para 23 at page 579, my lords. 579, my lords.
Yes.
Para 23, my lord. My lord, because there are cleavage of judicial opinions and the 2 judgments, my lord, matters referred to this larger bench, and the ratio laid down is 23, my lords. This is the answer to that question. As a result of the efforts of discussion, in our view, clearly the law that at the time of framing charge or taking cognizance, the accused has no right to produce any material. Material includes documents, my lords. Documents also includes any orders of the honorable courts, my lord. Satish Mehra case holding that the trial court has power to consider even materials which the accused may produce at the stage of section 227 code has not been correctly decided. The entire case of my learned senior, my lords, with great respect, my lords, falls within the ambit of the law laid down in Satish Kumar, because he got particular orders, which is a materials as per the Honorable Supreme Court's language, my lords, and he produced at the time when the discharge application was considered, my lord. Can the trial courts, my lord, legally permitted to place that one? In fact, I feel, my lord, the action or inaction on the part of the learned trial court in not paying any heed to this particular submission, or even documents, my lord, produced by the accused at the time of consideration of this application, that too under section 227 CRPC, my lords, cannot be faulted with, my lord. Lordship, last occasions, paragraph I would like to place it for lordship, that part 29, my lords, I place it number of times, but at the cost of reputation, I place it at page 581, my lords. Regarding the arguments of the accused having to face the trial despite being in a position to produce material or unimpeachable characters sterling in quality, the weight of the powers of the High Courts under Section 482 of the Codes and under Article 226 of the Constitution is unlimited, whereunder in the interest of justice, the High Court can.
You say that
That's-
whatever he has done, that could have been tested in 482 petition, not
In
in
fact, my lords, in consonance with this particular law laid down this on the court, my learned friend's client, in fact, resorted
Have
to.
you tried in 482?
He tried, he failed, and he now tested and with a narrow scope of criminal divisions.
Let me just reply that. Your Lordship may see a novel argument is being advanced contrary to the order passed by the trial court. Trial court is not saying that I'll ignore Supreme Court judgment.
No, my point
The
is
way
whether.
trial court has dealt with kindly similar, this is argument completely beyond the purview of the trial court's
No.
order. Trial court is
I say
saying
that could not be
trial court
produced.
is accepting the Supreme Court's, let the trial court pass an order ignoring the Supreme Court's order.
No, he didn't.
Trial
ignore.
court is considering.
You have
Supreme
no
Court's
right
order.
to place.
Then
Forget
how
about.
are you arguing
Forget.
that the Supreme Court's order is a document of defense by the petitioners?
No, it's not. It's a sterling
not.
in nature. You can't place it
So
in.
it's not a defense document.
Anyway,
My lords, my humble submission, my lord, with the right of the accused to produce. Now they were being considered in proper perspective or not. My lord, in fact, that is the submission. That these Supreme Court orders, which are material in my hands as an accused, I place it before the London Trial Court. London Trial Court considering my application 227. He has not considered it. I don't say they consider. They didn't consider in proper perspective. That was the entire case of the Mr. Rathmalords. And now the second point is, the Lord, he pleaded many things. That whether that pleadings can be construed as defense plea, and if the defense plea can be raised at the time of consideration of discharge application, no. That answer has been, law has been set in place that defense plea can be raised always in the trial, during the trial, Lord. And trial comments after framing of charge, Lord. My humble submission, Lord, in fact, relying on this particular judgment, and my learned friends, clients were rightly advised, and they resorted to the mechanism provided by the Supreme Court in para 29, and that's why, Lord, they invoked the power of this on court under 482, being aware of the fact for quashment of the entire proceeding, 482 is the appropriate forums, and my lord, the Supreme Court orders was placed into service, and this honorable court considered it, and ascribed reasons. The reasons may not be for 2-3 paragraphs, but this cannot be say that the judgment of this honorable court, my lord, in 482 application has not ascribed reasons, my lord. I understand, my lords. My lords, reasons, my lord, 1-2 orders are rejected. But here the Honorable Supreme Court saw the judgment of the Supreme Courts and distinguished this judgment of Supreme Courts that this Supreme Court judgment pertains to a quashment of a particular demand notice. And Supreme Court also rightly said that the assessment made by the recommendation of the Excise Commissioner, his authority cannot be challenged. We also agree that, lords, we don't say that any fault in that particular Supreme Court orders. We also complied. We complied. What are the directions there? We don't say it's a bad orders. My point is that, my lord, where is the culpability of the accused persons, my lord? What is the complete, my lord? The Honorable Supreme Court said that, my lords. My lord, before I delve into that matters, my lord, let me clarify in 2 lines, my lord. The entire submission of my learned senior says that this particular copy of that honorable court's order is unimpeachable characters. I have every right to place it, and on trial court, while not consider in proper perspective. My humble submission, at the outset, he has no right to place any documents because the 227 application is to consider only on the basis of the charge sheet. And the Honorable Supreme Court said, whatever the materials produced with prosecution should be considered as proof. I place that particular judgment of the Supreme Court. I just 1 line, my lords.
Yes.
At the time of consideration, this is 2010 report. At the time of consideration of discharge application or framing of charge, the probative value of the materials on records cannot be gone into, and the materials brought on record by the prosecution has to be accepted as true. And my lord, now you have some documents and you placed it rightly on 482. You failed there. and try to find out the flaws in that particular orders, though that order of this Honorable Court passed under 482 application is absolutely based on regions. And I must say, it has laid down the ratio. You'll also put me the question, what is the ratio? Ratio is in a particular judgment is the regions on which the conclusion the court raised. And in this case, my lord, the conclusion of the court pertaining to the place advance and the place on which the pleadings was there, and this Honorable Court, while disposing the 482 application, after perusing the Honorable Supreme Court's orders, laid down the law, ascribed the cause and reasons for that. So the order of this Honorable Court in 482 is based on regions, my lord. That cannot be faulted with, my lords. Yes. And now, my lords, after failing that, my lord, they put it before the London trial courts, where he is forbidden to look into any documents placed on behalf of the accused, the defense counsel's, my lord. And now he considered in different way, and he rightly rejected it, my lord. And that is being viewed adversely, saying that you have not considered in proper perspective. Two, that the place I placed before this London trial courts at the time of constitutional application was also not considered in proper perspective, my lord. Now the Supreme Court said, what is the parameters? The parameter is why even your arguments, your place of the defense should be in pertaining to the charge sheet, not beyond that. You started arguing, placing their defense plea pertaining to the judgment of the Supreme Court, which is the documents in your hands. That is not a part of the charge sheet, not the materials produced by the prosecution. These are the two submissions with regard to legal proposition. Yes. Let me come to the second point, my lords. Now, my lords, before I place the individual complicity of the petitioner, and the Honorable Supreme Court said, only if the materials produced by the prosecution diverse or they disclose great suspicion, then, my lord, on suspicion, charge can be framed. This is the settled legal position, my lords, and law has been set into Lisbon since time immemorial, my lord. On suspicion, now the Honorable Supreme Court added then what? Strong suspicion. If that material produced by the prosecution disclose strong suspicion, charge can be framed, my lords. Now, what are the materials deployed by the prosecution which unequivocally indicates the complicity of the petitioner, that disclose the great suspicion with regard to the complicity of the entire alleged offences, my lord. I will place that, my lord. Before that, my lords, I crave your lordship permission to place two judgments. One I place, my lord, another judgment I will place regarding the scope of this honorable courts under the revision jurisdiction, my lord. I'll just play few lines. I will not place the entire judgments, my lords. My lord, this is a judgment of 2023, volume 6, SCC, page 768, my lord. I'll just put three flags, my lord. I'll just put two paragraphs, my lord. Lords, may turn to the first para 2, my lord, about the factual aspects, my lords. Para 2, my lords. Appeals are at the instance of the state of Tamil Nadu through the Deputy Commissioner of Vigilance, so-and-so anti-corruption, directed against the two judgments and orders passed by the High Court of Madras, allowing the criminal revisions applications by the respondent, wherein discharging them from the prosecution of section 32, so-and-so. Lords, you may turn to the yellow flags, Lord, paragraph 15.
15 and 16.
Lord, these are the submission put forth. Thus, while rejecting the discharge application filed by the respondent therein, the London Special Judge recorded a categorical finding that there was more than a prima facie case against the accused persons to put them to trial for the alleged offense. The London Special Judge accorded a clear finding that the charges leveled against the accused persons cannot be said to be groundless as to the discharge them from the prosecution in exercise of power under section 239 CRPC. Para 16, the respondent being dissatisfied, the order passed by this special court rejecting that this application went before the high courts and challenged the orders by filing criminal revision application under 702 or so, respectively. Both the revision application came to be heard by the high courts anonymously and came to be allowed by the common judgment, so. The respondent therein came to be discharged by the front prosecution. Lords, you may turn to the green flags, lords, at paragraph 47. Yes. Paragraph 47, green flag. Detail. I hope your lordship got it. Yes. Paragraph 47. Now, the reason why we say that import orders passed by the high courts are utterly incomprehensible is because the High Court has not been able to comprehend the true scope and ambit of Section 239 CRPC. Here is 227, my lords. The High Court has also not been able to comprehend in what set of circumstances the revisional courts under Section 397 read with Section 4 and 1 CRPC had to be exercised. Let's just skip the 48, 49, my lord. The Learned Counsel appearing for the state rightly submitted that at the stage of consideration of discharge application 239 CRPC, only prima facie case is to be seen, and the special court having recorded a satisfaction with regard to the existence of prima facie case, then there cannot be said to be any material error or illegality in the orders SL before this honorable court's law. Para 15, my lords, the primary consideration at the stage of framing of charge, the test of existence of prima facie case at the stage the probative value of the materials, the court cannot be gone into. Lords, we turn to the last portion, lords, the orange flag notes at page, lords, so that paragraph 79, lords. Thus, the revisional power cannot be exercised in a casual or mechanical manner. It can only be exercised to correct the manifest error of law or procedure which would be occasion injustice. So and so on. Let's turn to the next paragraph. This is the important paragraph, paragraph 80. Let's turn to the next page. Page number is 815, lords. This court in Asian Surfacing Road Agency so and so has held that the interference in the order framing charge or refuse to discharge, this is a case followed in this category, refuse to discharge, is called for in rarest of rare cases. Is it that rare of cases? I put that question to myself. Is it a rare of rare cases, my lord? And that too, my lord, where only to correct the patent error jurisdiction. I understand, my lord, says so Central Administrative Tribunal passing an orders, my lord, which is without jurisdiction, my lord. Here, the competent court of law passed that particular orders, rejected its application. How these two parameters been accepted? This Honorable Supreme Court's, my lord, this is binding on Article 441. This is binding on the court that what is the scope of interference under revision jurisdiction? You failed to satisfy this honorable court while resorting to 482 application. Now you want to test the the power of this honorable courts under revision jurisdiction. And my lords, and that too, my lord, if at all you have got an arguable points, defense plea can be raised always before the learned trial courts, not before the stars at the stage when the discharge application is being considered. This is the law has been set in place, my lord. There cannot be any argument against that, my lord. Now coming back to the individual complicities, my lords. And what is the culpability, my lord? With regard to the power of the Excise Commissioner, my lord, we have not disputed, my lord. This on what Supreme Court said. Supreme Court said we quash the demand notice, and the power of the Commissioner of Excise, my lords, is absolutely unquestionable with regard to fixing, my lords. But what is the culpability? Lordship may put me a question. What are the materials which disclose great suspicion with regard to individuals, the petition of a lordship, lords, in so far in hatching the conspiracy to enable this particular Mr. Jaisal, my lords, to be entriched to the 1 crore 36 lakh loss to the government's, my lord. And on the basis of, my lord, by suppressing and misleading notings, my lord, and suppressing the materials, particularly the basis of calculation. Now, lordship may turn to, lordship may kindly permit me, my lords, permit me to place from paragraph page 3 of the notes, my lords. In the instance case, I'm placing the third paragraph, notes. I will not complete the entire, I will just place few ones more. Did you also get a page 3 notes?
Yes.
Other note, notes. In the instance case, the materials brought on record by the prosecution with the London trial court disclose great suspicion, and such materials reasonably connect the accused petitioners with the offense. Further, there is no such dispute as to the extent of authority of the Excise Commissioner, as has been observed by the Honorable Apex Court. But the Excise Commissioner had given misleading statements in connection to the production capacity of the plant in question, quite deviating from the PRC, my lords. PRC, my lords, issued by the industrial department, industrial unit, my lords. PRC, on the basis of which the production capacity is required to be calculated. My lord, the calculation we don't challenge. The basis of calculation, my lord, the PRC, my lords, their production capacity, that is to be ascertained at the time of registration, my lord. The PRC of accused Mohan Jaiswal is the petitioner of lordship, my lord. never reveals that it has got production ability of 1 lakh liters. Rather, as per the said PRC given after spot verification, the DIC has the capacity to 15 lakhs liters. The crush in dispute is not to challenge the authority of the commissioner. That's why we accepted the Honorable Supreme Court's orders. That's good, no problem. We complied our access, but the way, you'll also turn to next page, my lord. What were the grievance? The way it has exercised its official position, suppressing material facts as to the production, strength of the high-tech bottling in which commissioner and his policy set staff, the present petitioner, had manipulated, particularly showing the installed capacity of the plant of the accused Jaiswal. Further, the Honorable High Court, in CRLMC so-and-so has been praised to deny quashing the proceeding of the case.
What is the material for showing manipulation?
The materials, lords, we may turn to page 7, lords. The page 7, lords.
Yes.
Page 7, I'm pacing from para 2, lords. The charge sheet further reveals that on receipt of the permanent registration certificate from the bottling plants, accused Nursinga Charana Ponda, in this criminal division number 860, he belongs. A junior assistant, policy seat commissioner of excise, gave a note, my lords, he laid the foundation, my lords, of culpability, my lords. Note in the MJQ fixation of bottlings, plant white file number so-and-so, mentioning that according to the government notification, bottling units acts to furnish the PRC reports issued by the DIC for ascertaining the installed capacity and simultaneously prepared as statements showing production capacity and the MGQ of all bottling plants for the year 97-98. The note of the statement, they know the junior assistants were countersigned by the another accused, the Dinabandhu Patna, this criminal division 815 and 18, senior assistant of the policy seat, and then accused Babaji Charana Khuntia, criminal division number 858 in this case, section officer, policy seat submitted the note to the accused Kartik Chandra Das, Commissioner of Excise, the case against whom abated due to his death, who approved the note as well as the statement showing the production capacity and the MJQ on 9/2/98. The government by Deputy so-and-so approved the fixation MJQ relying on the letter so-and-so, milords, while approving the MJQ recommended by the Excise Commissioner. The government asked Excise Commissioner to submit permanent this is PRC, permanent registration certificate issued by DIC in support of the actual installed capacity of all the distilleries and bottling plants of state for verification. But the deceased accused, who was the Commissioner of Lords, a Commissioner of Excise, Kartik Chandra Das, Excise Commissioner, did not comply with the requirement of the governments. The charge sheet further reveals that the accused Manoj Jaiswal, criminal division number 861, milords, owner of the high-tech bottling, had secured PRC from DIC Sambalpur on 25/11/95, fixing the installed capacity of the unit per annum as 15 lakhs liter. It is alleged that besides that high-tech bottling plants, the production capacity MJQ were correctly mentioned in this statement according to the actual installed capacity. According to the actual installed capacity as mentioned in the PRC issued by DIC. In case of high-tech bottling, it was reported as 1 lakh liters in place of 15 lakhs liter, and accordingly the MJP come down to as low as 50,000 liters in place of 7.5 lakhs liters, being 50% actual installed capacity. Accused petitioner Narsingh Ponda, while preparing the statements to governments, reflected the production capacity and MJQ so-and-so bottling plants of 1 lakh PL and 50,000 LP respectively. It is alleged that these four accused persons of the Excise Commissioner Cuttack, in connivance with each other, showed undue official favor to accused Manoj Jaiswal by suppressing the actual figure and instead sent wrong figures of production capacity and MJQ in respect of Mrs. high-tech bottling plants, and thereby allowed pecuniary advantage to the manufacturers, Mr. Manoj Jaiswal, in shape of excise duty revenue at the cost of government exchange. It is also alleged that for fixation of MJQ, Commissioner Excise is assisted by the Deputy Commissioner.
Long and short of the matter is,
They initiated a particular, they try to ignore this PRC, which is the foundation.
The long and short of your argument is the Annexure 4, which was placed in Supreme Court on the basis of which Supreme Court had passed the order. That annexure is a culmination of the lot of manipulation done by them. So therefore, the culpability.
I couldn't follow, my lords.
the annexure 4, which the Supreme Court has relied upon, on the basis of which the judgment was passed, is a culmination of the manipulation and therefore the culpability.
That order, my lords, there are two aspects, my lord. The authority of the commissioner to write letters, and that can be the basis. But
the letter
what is the foundation? Foundation of these
no,
letters?
Letter is written by the
competent authority
on the basis of the feedback supplied by these people.
And deliberately
You say that the feedback itself is manipulated.
And why, in which way? The installed capacity, my lord, is to be ascertained at the time of registration of the
Whatever,
unit.
that is manipulated
any
and that
unit,
could
my lord.
only be tested there in trial.
And they completely ignored, they didn't mention, they neither annex that part of PRC, my lords. They only, my lord,
The annexure 4 which you are showing is a part of charge sheet?
Yes.
That was a part of charge sheet.
But this is only one piecemeal later, my lords. How that saw the light of the day, my lord, nobody understands. The Supreme Court at that point was never argued, my lords. The Supreme Court was approached on the point of a quashment of that demand notice and saying that Excise Commission has authority. Supreme Court said, yes, under this rule, so the Commissioner Excise has the authority. We also don't dispute, my lord. The letter was practically raised on that particular wrong notings, more particularly ignoring the registration certificate.
You accepted that position, not going further, and now you are invoking the revisional jurisdiction. How will you stress the jurisdiction
to do that?
Yes.
My part. I'll reply to that.
Yes.
My lords may kindly see, Mr. Das did not say that out of 4, only one accused had approached 482, not all.
Right.
Not all. Only one had approached 482. He is losing upon. Rest all have never approached this honorable court.
Okay.
That is one. 2. My lord, I have taken note of the submissions, but one by one. First of all, my learned friend Mr. Das says, see what is the date of the charge sheet. It is sometime in 2008, 25/4/5/2008. Now, what is the date of the Supreme Court's order? 2009. 1. 2. My lord, honorable Supreme Court's order. But I'm just giving an example. Today, what is the document we are giving? That is order passed by the Honorable Supreme Court. Suppose today in a criminal trial or a criminal case, arising out of the fact, an order is passed by this court. Can it not be brought to the trial court's notice at this time of discharge application or charge framing application? It's an order passed by a court. It's not a defense. Suppose a judgment is being cited. At the time of arguing a matter, we are citing a judgment.
That's the law of the land.
That's the law of the land. Under Article 141. How can you debar me from citing a judgment passed by the Honorable Supreme Court before the discharge court? But by styling, by trying in the way of your artistic submission, what are you trying to prohibit us from citing a judgment of the Honorable Supreme Court? Suppose that would not have been case in this case. Suppose a judgment would have been passed. Can I not cite it before?
You have relied upon 2 things. One is that annexure 4 to the
Correct.
order, and second is judgment of the Supreme Court.
Right, ma'am.
Annexure 4 was part of record.
Part of charge sheet.
Part of charge sheet. And judgment came subsequent to the
charge sheet.
That's what the distinction.
Yes. Now your Lordship may kindly see. What are you saying? That you are not disputing the commissioner's fixation. And you are saying that the manner in which it is fixed is incorrect. But the commissioner's fixation is based on the manner and upheld up to Honorable Supreme Court. If you are opposing to the manner, then you are opposing the fixation as well. And you are opposing the Supreme Court's order as well.
Yes.
You can't oppose. Because what I say, my lord, I have therefore that's the reason I knew that this argument will be advanced. I cited two laws. One is the relevant prevalent excise rules 97-98, which do not say anything about the DIC registration certificate. What are they saying? They are saying that the fixation should have been in terms of DIC registration. But here the fixation has been done in terms of the extant policy and rules. Excise rules 97-98, if your lordship sees, part of the record.
Yes.
Lord, kindly see. Does it whisper about DIC? Kindly see, my lord. The fixation, recommendation, notice in the file, are strictly in terms of the law, strictly in terms of the prevalent rules. Kindly see, man. This is what is not being shown to my lords. See, rules study. Right? Kindly see, my lord. That is rules study annexed. It is here. Right. अरे rules टा exercise rules टा देखो ना और भोपांग वाला हो बस फाइल करছে हमें
35 page 35
1 second madam part of the records madam I have filed it. This fellow is not yes
page
35
6A
yes wow. Kindly see madam
6A
yes do not page 38 6C kindly see my lord page 38.
Yes, I have already marked it.
Yes, just see my lord, what is the criteria for fixation? This is the rules which will override the all executive instructions. Kindly see, all the licensee of IFL bottling plant shall a grantee of bottling of 50% of the instant capacity of the bottling plant in a year as the minimum guaranteed quantity. It doesn't say about instant capacity in terms of DIC registration.
It is the capacity, production.
Yes, production capacity. And what is my capacity? Their own charge sheet is there. Actual capacity is 1,09,000 per annum. So there is nothing wrong in this. And that too, I'll just show you policy also.
No, but what he says that it is the capacity which has been derived.
DIC registration.
That capacity, while deriving the capacity, that is manipulated.
No, where is the manipulation?
That's what he says.
But kindly see from the chart sheet, where is the manipulation? The actual capacity.
He says that it should be 1.5, not 1.
Based on DIC registration.
DIC
registration is not the criteria.
I understand.
And also the excise policy, my lords, may kindly see. The excise policy is in terms of the constitutional mandate, Article 251. Kindly see. Not in my, along with my written note, I have given that excise. Yes. Not kindly see. Policy again, excise policy in tandem to the rules also says the same thing. Page 16 of my written note.
Yes.
97-98 ବର୍ଷରେ ମଦ ବଟଲିଂ କରୁଥିବା ପ୍ରତ୍ୟେକ ବଟଲିଂ ପ୍ଲାଣ୍ଟ ପାଇଁ ତାଙ୍କର ବାର୍ଷିକ ଲାଇସେନ୍ସ ପ୍ରାପ୍ତ ବଟଲିଂ କ୍ଷମତା ଲର୍ଡସିପ୍ ସି 22 ଲାଇସେନ୍ସ ପ୍ରାପ୍ତ ବଟଲିଂ କ୍ଷମତାର 50% କୁ ନେବେ not the DIC restriction man. But out of air you will make out a case and implicate all these people and force them to face the criminal prosecution even after they have retired since long. All old people, they are not able to work.
Yes.
This is the excise policy man. And policy and rules do not speak about DIC.
Yes, Mr. Das, whether in the during framing of charge or discharge application hearing, they are no doubt prevented to rely upon documents. Are they prevented to rely upon the law?
Yes.
My lords, my humble submission, my lords.
The law in the form of rule, law in the form of judgment,
Yes.
law in the form of statute.
That was also
Can it be
in fact that was the
taken away? That right?
My lord, that question also came to my mind. My lords, my humble
And he is relying upon the Supreme Court judgment.
correct.
He's
my lord.
relying
I'm also Article 141.
These are the law.
My lords, I'm also aware the Article 141 is staring at me.
Unfortunately or fortunately, it has come after the charge sheet is filed.
Charge sheet.
My lords,
And you can't say that
out
this
of
was
the-
known to you. Why have you not done that? Situation could have been.
it has come from charge sheet.
Charge sheet is
After the
2008.
charge sheet.
After the charge sheet, yes, my lord. My lord, lords, you kindly bear with me 2 minutes, my lord, to answer this
Yes,
question,
of
my lord.
course.
Because this was a question in my mind last night also.
Yes.
That suppose a judgment will
Last
come
night,
up.
my learned Mr. Das did not sleep properly.
No, in fact,
No,
my
let us
lords,
have some light.
no, I understand.
He is very intensely arguing,
Very
sleeping and arguing.
Usually he is very intense. We face it very difficult to face Mr. Das.
In fact, also I have got
No,
equal
these
respect.
are law issues. We
My
have
lords,
to know.
my humble submission, my lord.
Yes.
My lords, I have got lot of reverence for the orders of the Supreme Courts, my lord. I'm also aware of the scope and ambit of Article 14 Constitution is binding throughout the world. Law declared is binding on all courts, including the trial court in which this application of discharge was considered. But at the same time, Lord, I bring to Lordship notice, my Lord, while the Honorable Supreme Court, while clarifying the the cleavage of judicial opinion with whether the accused has a right or to produce and document not, my lord. They could also visualize this kind of situation that even after the charge sheet, the accused may be in a position to get a particular documents of all the courts of order and all this thing. That's where the Supreme Court, in contingence, in keeping in mind, my lords, that what should be now. Yeah, the accused should not be helpless in even after framing after consideration.
Kind permission. I have come across one single judgment. It's immediately I'll give it also a copy to my knowledge. Yes. One single judgment is there where Honorable Supreme Court says that even at this stage of 482, the High Court can look into some admitted defense methods. Admitted.
482, you can do that.
There is no your tested failed.
What is the problem here is revisional jurisdiction arising out of an order rejecting your discharge application, and the face of it out of 3, one of them has gone to 482 court fails.
And my lord, the important question which came to my mind, my lords.
But the way the Honorable Single Judge has dealt with the matter, your lordship will find that it is quite unhappy. I mean, it's not very well reasoned order.
But you should have gone to Supreme Court to challenge that.
But your lordship, see whether the issues arising out of the discharge matter is being dealt with or not. One more submission of mine till now probably has not been answered. In the charge sheet, your lordship will find there are 3 lines I have pointed out that vigilance whole process is based on an audit objection report. Only after the audit objected, the criminal case has been initiated. There is a judgment passed by this Honorable Court 2012 boiler. I have given along with my note that based on audit objection, no criminal case can be initiated.
Correct.
No conviction can lie.
The judgment is there. I know that.
No conviction can lie. That judgment I have given 2012 one boiler.
It is there.
Yes. That's the admitted position. That's why she pays 37 of my note.
What about that test, whether if the court in a revisional jurisdiction arrive at a conclusion, the entire trial, exercise of trial would be bound to be a futile exercise.
Futile exercise.
Can revisional court interfere?
Yes. That is the judgment I will be giving. I'll also say
give that.
I'll give
if there is
then the 482 hurdle will go.
I'll give that.
No,
I'll give that.
on 2 grounds. On 2 grounds, my lord, lordship propositions is feasible. If it is absolutely groundless, 2, there are no matter to proceed. Except these 2 words, there is no third word. And my lord, humble submission, my lord, so all my learned submission, my lord, is excellent arguments for the defense, my lord. But the defense play always, my lord, you have got the scope, my lord, before the trial, my lords. But these are the defense play. But this is not a case that all the accused persons, my lord, who created the foundations and ignoring the registration certificate at the time of registration, my lord, you assess the distillery's install capacities. You ignore all this thing and started resorting to different rules, regulation. These are the good grounds of defense, and defense plea can be raised before the trial. But this is not a case which can be considered as absolutely no materials to proceed. It's not a
trial on facts. Law has to be taken at any stage. If these are not factual dispute, if he relies upon a law, wrong, right, whatever, if the law is there in his favor, it has to be considered. Trial is only on facts. To test the factual, you have to separate the grain from the sand. That is the idea of right. If he is relying upon law, how will you come out of the law?
The law, my lord, is for the defense to, if there is any kind of judicial pronouncement order is there, my lord, for that contingency, the Supreme Court provided a mechanism. Look, you are the accused. You have no right to produce. But what if you have got any sterling nature documents?
He's not producing document. He is producing the
that's why I say I am not document. I am not considering materials. Or no, Supreme Court orders can be considered as materials or not. If it is a materials, my lord, he is precluded in producing it. But he is not remedialess. He can resort to 482. In fact, they have resorted to that mechanism, failed there, and tried yet notes. Tried and
one of them.
But the same orders. They rely on the same order. That order was put to test by this honorable court. 482 application could not be exercised in their favor, and revisional power will be exercised.
That is staring on the face of record.
I'll try to come out of that by citing that
problem.
I'll come out.
That's the problem you have to get.
I'll come out of that by citing the other judgments.
And I also wish
all these arguments hold good for 482.
Correct. Agreed, my lords.
One person, that judgment is not happily worded, doesn't deal with the points which I am now raising.
Suppose
it's a pure question of law and it was not dealt with in a judgment. Can you bind us and say that?
Raise all
You
this.
just
I'll
give me a
cite,
judgment
Yeah.
I'll
so that the law can be cited even at this stage.
Yes, I'll
And
give
the charge court has to take the law into
in a
consideration.
couple of days, I'll give it.
And with your lordship permission, I wish my learned friends safe journey and enjoyable weekend.
Thank you.
He's
Thank
going
you.
to Sundargarh.
He must enjoy it.
Thank you. So grateful, my lord. I'll give it in a couple of or 3 days.
Please do that. Only you distinguish that part, then you have a case.
I'll give it.
Yes.
It almost page mark.
Judgment reserve.
The page mark.
Yeah, page mark. Judgment reserve and give.
Now, can I pray, my lords? So my learned sister is ready,
Yes,
my
yes,
lords.
yes.
That cancer patient, my
Yes.
lords.
44 weekly.
अच्छा भाई ना आपनों को अच्छे
21.
भाई ना बहुत
He
समय
has a
बसना
difficult case in the sense the somebody is suffering from cancer or something.
In fact, at Pion, he has taken his mother to the cancer hospitals.
Like regular item 21 in the supplementary list. Can it be taken up on Friday? The other matter you are also.
Yes, definitely.
Next Friday.
Friday. So both the matters you can do it. Very good. Yes.
And Mr. Mishra also started watching this case for at least for 10-30. And I had the opportunity to interact with him a lot. He was a state counsel for a number of years.
I think he must be enjoying the proceeding, therefore he is there. Otherwise, yes, madam.
May please, Your Lordship.
Lordship,
Your Lordship, the present appellant has been convicted under section 468 and 471, Your Lordship, by the ad hoc additional session judge, FTC number 4, Bhubaneswar, Your Lordship. Your Lordship, the fire allegations and the allegations taken in entirety is that I have essentially produced 2 essentiality certificates and 4 cash memos, Your Lordship. Those are in Exhibit 5 series, Your Lordship. Those cash memos, while were being considered, while it was being considered that money will be disbursed in my favor, Your Lordship, the concerned government officer suspected that the cash memos are forced in nature due to overwriting, Your Lordship. And thereafter, he has sent the same to his higher authorities, and subsequently, out of the money that I had sought for, a part of that money has been disbursed in my favor, Your Lordship. But they have forwarded my application to the vigilance authorities, Your Lordship, wanting a prosecution under section 13 of the PC Act and 468, 471 of the IPC, Your Lordship. They could not find sufficient materials to proceed against me under the Vigilance Act, PC Act, Your Lordship. That, however, sanction has been sought to proceed against me under section 468 and 471 of the IPC, Your Lordship. After the submission of the charge sheet, charge was framed, and subsequently I have been convicted by the Special CJM Vigilance Bhubaneswar, Your Lordship. And I have sought for an appeal in the sessions judge. The sessions judge has also convicted me of section 468 and 471 of the IPC, Your Lordship. There are 12 prosecution witnesses, Your Lordship. Witness number 11 and 12 are the investigating officer. However, the learned trial, the court below have relied upon the evidence of PW 1, 4, and 6. The proprietor of the places from wherein I have been alleged to have collected those cash memos, Your Lordship. May I take Your Lordships to the evidence of all those PWs, Your Lordship?
You have a copy?
Yes, Your Lordship.
You have extra copy?
Your Lordship, I have the copy. I had taken the record, Your Lordship.
Yes.
PW1 is Deepak Das, Your Lordship.
PW1, huh?
Yes, Your Lordship.
Yes.
I am the proprietor of Sanjeevani Medical Store situated in Mangalabagh, Cuttack. I used to give printed cash memos to the customer. The medicine bill contains the name of the doctor as well as the name of the patient. The original cash memo is a printed one with white letters with blue background. PW1, Your Lordship, Deepak Das.
Yes. Yes.
Yes, Your Lordship.
Ready.
Yes, Your Lordship.
Yes.
First paragraph, Your Lordship. Vigilance staff once verified the bill of my shop with the same type of bill, which do not belong to me. the duplicate bill which was shown to me was not issued by my shop and that no such medicine was sold by me. After verification, I told them the bill shown to me was not issued by me. Para 2. One bill book consists of 200 cash memos. Vigilance officer had seized the duplicate book from my shop, for the period from 18 to 2003 to 27 to 2003 and prepared Caesar list so and so. Exhibit 2 is the said bill book. There is no such serial number bearing 86389 dated
What you
22
say in
2000.
this?
Your Lordship, I will take your Lordship to
disowned that,
cross.
clip.
Yes, Your Lordship.
Yes.
He disowns Your Lordship. From this particular medicine shop, Your Lordship, the cash memo that I have submitted is 86385.
Yes.
That is the cash memo number, Your Lordship.
8,
5.
5, yes.
Yes, Your Lordship. He says that there is no such serial number bearing 86389 dated 22/2023. In the name of Lakshmi Devi as revealed from Exhibit 2.
It doesn't say anything 385.
385. It's not said. He doesn't say. They have seized the cash memos pertaining to the date, Your Lordship. So admittedly, the entire allegation rests upon me because I have produced certain cash memos where there is overwriting. That overwriting is admitted on my part, Your Lordship. That is admitted on my part. But does that overwriting will amount to forgery? That is the question that has to be considered by Your Lordship. And in the cross-examination, he says, a bill book consists of 200 cash memos and all the bill books are numbered. I cannot see the number of bill book containing page number 8000 to 9000. The bill book containing serial number 86389 has not been seized.
Yes.
I also cannot say the bill number 86389 belonged to which customer. According to date, the vigilance staff had seized Exhibit 2. It is according to date, the vigilance staff had seized Exhibit 2. It's not a fact that I have suppressed the bill book containing cash memo number 86389 as it was issued in favor of Lakshmi Devi. It is not a fact that I am reposing falsehood at the instance of the police. Your Lordship, what is to be taken into consideration here is paragraph 3, the second sentence of paragraph 3. I cannot say the number of bill book containing page number 8000 to 9000, Your Lordship. The bill book containing serial number 86389 has not been seized.
Okay.
This is one medicine shop proprietor, Your Lordship.
This is the bill book, the bill which you have
Yes,
submitted.
one of the
It
bill
is not
books.
seized.
He says that.
Then
He
the
says that.
photocopy must be.
Photocopy. He says that that particular serial number that has not been seized, Your Lordship.
Maybe a separate, he might not have printed it, obviously.
He doesn't say that. He doesn't say that.
It must be photocopy.
Your Lordship.
In photocopy, there must be manipulation.
Yes, Your Lordship.
Maybe, that may be the reason.
That may
Yes.
be the case.
Yes.
Your Lordship, thereafter I will take Your Lordships to PW 2 and 3 are Your Lordship only Caesar witnesses, Your Lordship. That 146 are the important witnesses. So I'll take Your Lordships to PW 4, Your Lordship. PW 4 is named as
How many bills? One, this you have
Yes,
demonstrated.
yes,
What
Your
about
Lordship.
others?
4 bills are there, Your Lordship. This particular PW 4, there are 2 bills from Sangam Medical, one from Bhanja Medical, and one is from Sanjeevani. So the first one I took Your Lordships through. So from PW 4, Your Lordships, I have been working in the Ramachandra Bhanja Medical Store since 1997. I, along with other staff, used to write the cash memo.
Worker.
Yes, Your Lordship. It's one of the workers.
Hmm.
I, along with other staff, used to write the cash memo. In every cash memo, patient name is mentioned. At this time, it's not possible to, at times, it is not possible to note the name of the doctor due to busy transaction, Your Lordship.
Yes.
Your Lordship may note this. On 9/8/2004, vigilance staff seized used cash memo book bearing number 6001 to 6400, Your Lordship. and prepare seizure list, Your Lordship.
What is the number here?
The number here is cash memo number 4014. 4014.
4014.
Ha. However, they have
In a PW1 case, what that was 39. What is what?
86389. 86389.
86389.
Yes, Your Lordship. So here, Your Lordship, again, on 9/8/2004, vigilance staff seized used cash memo bearing 6,001 to 6,400, minus 4,014, Your Lordship, and prepared seizure list, which is marked as Exhibit 7, Exhibit 7 therein. Each page consists of 4 number of cash memos. On 21/5/2004, the vigilance staff collected sample cash memo of our shop, which I signed, and also the IO of the case signed. Therein, the case memo was cancelled, which is marked as so-and-so. Your Lordship, I'll directly take Your Lordships to the cross-examination, Your Lordship. Para 4. Unless I see the original, I cannot say whether the cash memo amounting to rupees 130 belongs to our shop, Your Lordship.
The original is not 70. Yes.
Unless I see the cash memo number 4014, I cannot say the date of issuance of such cash memo, Your Lordship.
That was not shown to him.
That is what my point is. Unless the same cash memo, whether the copy of it is confronted to him, how will a person say that the cash memo has not been issued or has been issued by him?
PW1 says that the original was never produced.
Yes, Your Lordship.
And he says that it was not shown to him.
It was never.
Also,
Then-
these two memo goes
Yes,
according to you.
Your Lordship, I'll take Your Lordship to further also. Then again, he says, after 2 lines, the vigilance staff has not seized the cash book containing 4014.
Same here.
Same year. Unless I see the cash memo, I cannot say to whom 4014 was issued. Then again, it goes on to say, total 3 employees were working during the relevant period. My name, Niranjan Sahu, myself, and Mr. Badal. They are no more in service. At times, the employees also issues.
He repeatedly says, unless it is shown, I can't say anything.
Yes, Your Lordship.
He repeatedly says.
Yes, Your Lordship.
I cannot say whether there are another number of shop.
Yes, Your Lordship.
in same name.
Unless I see 4014, I cannot say who has issued the same, Your Lordship.
He is hostile? No.
No, he's not hostile, Your Lordship.
Yes.
He's not hostile, Your Lordship.
These 2 memo goes. How many memos you have?
2 more memos. 2 went and 2 more memos. PW6 will be for 2 more memos, Your Lordship. PW6 is Anjan Kumar Sahu, Your Lordship. I am the proprietor of Sangam Medical Hall, situated at Rani.
PW6,
Your Lordship. Anjan Kumar Sahu, Your Lordship.
Hmm.
I am the proprietor of Sangam Medical Hall, situated at Ranihat, Cuttack. I, along with my younger brother Ashok Kumar Sahu, are the proprietors of Medical Hall. We used to issue cash.
This case memo is 5501.
Your Lordship, this cash memos will be 750.
2 memos.
Yes, 7503 and 7508.
7503 and
7508.
7508. ठीक है.
Yes, Your Lordships.
Yes.
We used to issue cash memo to our customers. There's a separate cash memo book. On 9/8/2004, the Vigilance Police has seized 2 cash memos. One is book number 7, containing from serial number 3001 to 3500.
Yes.
And book number 12 containing to 5501 to 6000, Your Lordship. So
this is 7000.
This is
Series.
minus 7000.
7000 series.
Yes, Your Lordship. Minus 7000 series. These 2 books were seized by the vigilance by Caesar Exhibit 12 and 12/1. The said book, that is book number 7 and the book number 12, there is no such cash memo bearing serial number 7503 dated 18/4/2003 and serial number 7508 dated 18/5/2003. So, Your Lordship, admittedly, there is a discrepancy between the memo number and the date, Your Lordship. Admittedly, there is a discrepancy, which is evident from Exhibit 13 and 14. Of course, Your Lordship, if you are seizing the another serial number, the concerned date will not be reflected from there.
Right.
The above mentioned cash memos were not issued. He is talking about Exhibit 13 and 14. He is not saying about Exhibit 5 series, Your Lordship. Herein he is saying about Exhibit 13 and 14, the above mentioned 2 cash memos were not issued by our Sangha Medical Hall, and that the said 2 numbers are the not cash memo of ours. Thereafter, Your Lordship, certain Xerox attested cash memos were collected by the Vigilance Police. Your Lordship may note this. Certain Xerox attested cash memos were collected by the Vigilance Police from our shop, which includes 7503 and 7508, Your Lordship.
Xerox one.
Yes, Your Lordship. So here, Your Lordship, why I point out this is certain Xerox attested, Your Lordship.
Who is attested?
That is the whole point, Your Lordship. They are not questioned that who has attested that. So if this particular
Where was the occasion for attesting or something, anything?
and they are not saying
Cash
that
memos are cash memos.
and they are not saying the prosecution allegation is not that this attestation is wrong, Your Lordship. They are not saying that this attestation is wrong or attestation has a element of forgery, Your Lordship. The cash memos number 7503 relates to 16/11/2003 and 7508 also relates to 16/11/2003. Those cash memos are there, Your Lordship. There on record. Both the cash memo do not reveal the name of the patient. Your Lordship, thereafter in the cross-examination, cash memos are prepared by me as well as by other employees, including my younger brother, Your Lordship. Again, this gives rise to 2 views, Your Lordship. Generally, the name of the patient is written in the cash memo, and at times, due to busy work, the same is not noted, Your Lordship. So, in the chief, he says the cash memo does not reveal the name of the patient, Your Lordship.
But it may be written, may
May
not
be
be.
written, may not be written, Your Lordship. It's not a fact that the cash memo relating to 7503 dated and was issued from our shop. It's not a fact that I'm reposing falsehood.
Correct.
So, Your Lordship, my whole contention is that to bring a conviction under 468 and subsequently under 471, Your Lordship, the section 468 says whoever commits forgery, Your Lordship.
Yes.
Herein, Your Lordship, the prosecution allegation is not against me, is that I have committed forgery. They are saying you have produced a forged document, Your Lordship.
Who has done, nobody knows.
Who has done? Nobody. Leave aside that also, Your Lordship. What is the element of forgery that is present in those cash memos? That has not been pointed out to me.
Right.
Overwritings, Your Lordship. But whether those sustained overwritings or those sustained discrepancies will amount to forgery, Your Lordship. They will amount to forgery only when the standards laid down in section 463 and 464 are met, Your Lordship. And 463 very clearly says whoever makes any false document, Your Lordship. There has been no finding by both the courts below, Your Lordship, that I am the author of those forged documents. Allegedly, even I am the author of those forgery, Your Lordship, those overwriting, Your Lordship. None of the prosecution witnesses are saying that they are disputing their own signatures in those cash memos, Your Lordship. And they're admitting, Your Lordship, that at times there are discrepancies in the cash memos, Your Lordship. Right. And also, Your Lordship, when we talk about forgery under 463 and 464, both an element of fraud has to be there, Your Lordship, to again convict me under section 471, Your Lordship, because I have used those forged document as genuine document, Your Lordship. They have also gone to the extent of ascertaining whether I was trying to defraud the exchequer, Your Lordship, but that was found false, Your Lordship. The fact that my mother was ill, that was correct, Your Lordship. Even the bill that I had sought for amounted to rupees 59,000 some odd, Your Lordship, but 40,000 has been sanctioned to me, Your Lordship. And then 40,000 has been incurred as health expenses of my mother, Your Lordship. So where is that element of fraud present in the present circumstances, Your Lordship?
Yes.
And Your Lordship, when 2 views from the PW 1, 4 and 6, Your Lordships, when that the first duty is always upon the prosecution to say that I have committed the forgery, or it was within my knowledge that such forgery has been committed, Your Lordship. It was when that duty has not been discharged by the prosecution itself, Your Lordship, the onus is not on me to go beyond reasonable doubt. My standard is that of preponderance of probabilities, Your Lordship, and in the defense and in the cross-examination of all the 3 witnesses, I have taken it out from their mouths that there might be some other person who would have written the cash memos, there might be some other person who would have attested, Your Lordship.
You never know, because the originals were not seized.
Yes, Your Lordship. But to ascribe, but to put Your Lordship, there only remains one element that has been discussed by the learned trial court, that section 106 has to of the Evidence Act, that since I have produced the cash memos, Your Lordship, it should be within my knowledge that these are forged, Your Lordship.
You have used that forged document, but whether you have forged or not, nothing,
Nothing.
no evidence has come.
No, Your Lordship. Your Lordship, again, you
Reading
have
this
used
three
that,
witness.
Your Lordship, again to say that I have used those forged document, Your Lordship. So the law has prescribed what is to be a forged document, Your Lordship.
Then what is that? 471.
Yes, Your Lordship. 464 says making a false document, Your Lordship.
But you are not making that.
I'm not making, Your Lordship. And
471 may be using a false document to be genuine.
yes, Your Lordship. Again, the thing is forced document, Your Lordship. Whether mere overwriting or mere discrepancies would, like the learned court can hold that it's a forged document. Because the attestation that is there on the cash memos, that is not disputed by the prosecution witnesses, Your Lordship.
The attestation of the after overwriting it was attested, or before overwriting it?
That has not been ascertained, Your Lordship. That has not been, that duty was upon the prosecution, Your Lordship.
That should have been asked.
That should have been done.
Yes. Anything?
Your Lordship.
So what are the findings?
Your Lordship, the learned trial court had framed two issues, Your Lordship. And in the instance case,
Have you checked if there is a composite charge sheet? If the sanction for particular offense is not granted by the authority, what will be the effect of that?
Your Lordship, I could not.
Because it is a composite charge.
Yes, Your Lordship.
Okay, composite thing, and under section 20, sanction was sought for.
Yes, Your Lordship.
And which was declined.
Yes, Your Lordship.
Declined.
Yes.
So in a composite charge sheet, if for the part of the offense, if the sanctioning authority doesn't give sanction, is there any bearing in the entire prosecution?
Your Lordship, I have checked on that, but there is evidence that there was a sanction against me for 468 and 471.
Sanction is given, express sanction
Yes,
is given.
yes, Your Lordship. That is there by one of the PWs, Your Lordship. That is why we have not taken that point.
How can the you tell me, have you checked it?
Your Lordship, from the
What is running in my mind is
composite.
who is the sanctioning authority to decide what will be the charge? Who is he? Prosecute him in this, prosecute him in that. Don't prosecute with him. Is he framing a charge?
Just apply his mind. He has to apply his mind.
Either you give sanction, you don't give sanction.
Not-
Who are you to say that this and the court will go according to the sanctioning authority and start doing things? Then virtually the sanctioning authority is framing charges.
Lordship is correct, Lord. He must
What is the position of law?
Your Lordship, I'll check again and come up with Your Lordships.
Try
because
to
I may
understand
not-
what is
yes,
happening.
Yes, Your Lordship.
Then every sanctioning authority will start reading everything, and they'll say that no, you prosecute him in this section, don't prosecute him in that case.
They're
section,
taking the
and
role
the
of
court is
court.
bound by that.
Bad
Yes, Your
precedent.
Lordship.
It is a composite charge. 13(1)(b), 13(1)(d) and all, and 468, 471. He says that insofar as 13(1)
No materials.
no materials, I will not give sanction. But you prosecute him in that.
He shat in the shoes of court.
Then he is deciding what will be what
Yes,
will
Your
be the
Lordship.
charge. And court has to go by that or what? And the court has gone by that.
Court has gone by that. But Your Lordship, as far as my limited knowledge goes, Your Lordship, courts have to look into the materials in their entirety, Your Lordship.
But what
Independent.
Independent of what has been suggested by the
can the sanctioning authority has so much.
Step in the shoes of a court to
So
decide.
that's what has happened here. So what will be the impact of those sanctions?
Only thing, my lord, sorry, lordship permits, my lord. These are the questions, my lord, to be answered, my lords. But lordship may.
On materials also there is nothing.
What I suggest, my lordship may record my 2-line submission that the impugn confirming judgments doesn't warrant any interference because
That is a common sense.
that's the findings of the Lord and Trial Courts, my lords.
It's a concurrence or no?
Yes, not against the weight of evidence or record, neither suffers from perversity, my lords. And your lordship will record this one. And second submission, my lord, with your lordship permission, my lords, Miss Mishra's preparation, my lords, he's not only articulate, my lord, he clinching the issue apart from this question your lordship put, my lord. It's commendable, my lords. I can say well done.
No, she has done very fantastic, very meticulously she has done.
Your Lordships, there
No
are,
doubt about it.
Your Lordship, there are two witnesses which are speaking of what the Lordships had put to me. Your Lordship, I'll just take some time to ascertain on that point because there are evidence.
Very well articulated and very meticulously prepared. So therefore, I expect much from you.
Yes, Your Lordship.
इसमें step in कर देना. And put it when do you want next Monday?
Next
Monday, Tuesday, whenever you want.
Whenever Your Lordship fixes up a date.
Huh? Tuesday.
Much obliged, Your Lordship.
Get that if you can cut hold of something.
Yes, yes, Your Lordship.
This is a
That will nip it from the bud, Your Lordship.
very interesting point to
Yes,
which you can deal with. Yes.
Item 6, I was mentioning about. Your Lord, I am seeing the clock.
No, in fact, he came earlier. He started thinking about other cases in other courts.
It is there.
No, my lord.
He prepares the brief proportionality with the material instruction.
My lord,
You
I
know
was
that.
engaged as a pro bono lawyer of my associate's sister's case in Mata. So that is pro bono, but I cannot ignore that it's my associate.
Anyway, let it be there on the board. If tomorrow we get time, we'll do it.
Tomorrow after lunch.
Yes, madam.
Your Lordship, item 130 for weekly matter. Can come tomorrow if Your
It's
Lordship.
there. You come if you get the time. We'll do it. Today, actually, I heard lengthy matters, 2-3 lengthy matters. So
It's a very small matter, Your Lordship will get over.
small for you, they will make it big.
Clock ticking at 4.
Tomorrow, my lord, tomorrow it's mentioned, my lord.
Tomorrow we'll do it. It is there on the board.
Yes, Your
Please.
Lordship.
Thank you.
Obliged, Your Lordship.